Thank you very much, Attorney Santiago, for kicking off our program with your inspiring opening remarks.
Now let's hear a special message from the Dean of the UP College of Law, Dean Darlene Berberabe, who has so kindly graced us with her presence this afternoon. Prior to assuming her role as Dean, Dean Berberabe built up quite the track record for honor and excellence both inside and outside the academe, serving as a senior lecturer in the UP College of Law, a professional lecturer on jurisprudence and legal philosophy at the Philippine Judicial Academy, and as the former Chief Executive Officer of Pag-ibig Fund. Under her leadership, our college is as steadfast as ever in pursuing Dean's vision to provide education that stimulates discourse and leads the nation by responding to technological and social change while maintaining its commitment to securing a just society. Everyone, please welcome Dean Darlene Marie Berberabe.
Hello, good afternoon to class of Professor Josephine Santiago in Law 194. Good afternoon also to GCC, Justice Roger Quevedo, the head of the commercial cluster. Thank you for inviting me to this very important symposium on right to life, liberty, and intellectual property, exploring the interplay between intellectual property and human rights. So as you can see, I'm mobile. Please excuse my setup, but I just wanted to say yes to the invitation to give welcome remarks for this very important symposium. And I would like to congratulate Professor Santiago and the commercial law cluster. Please, more of these symposia. I am very, as was mentioned in the introduction, I'm very much for new topics, emerging trends. I'm very much for exchange of insights, and hopefully we can come up with guidance for our decision makers in government, or some inputs in to amend our laws. So congratulations in advance. So what I understand is that the intellectual property and human rights, this course seeks to traverse both intellectual property and human rights and identify the areas where they intersect. So a human rights approach to intellectual property takes or involves often a balance between the rights of investors and creators on one hand and the interests of the wider society. As was mentioned by Professor Santiago, that was the challenge became very apparent during the COVID, when we had the intellectual property of the inventors for the vaccines and the availability or access of the society to this. So intellectual property regimes can really have an impact on a number of rights, like the right of the people to enjoy and access cultural heritage, or access by everyone without discrimination to the benefits of science and its applications. Or if you are into research, access of the researches to the scientific information and advances. So I am sure that the discussion will not be easy, and there are a lot of nuances. But I know that UP Law students delight in challenges, and they will always emerge successful in their scholarly pursuits. I'm also optimistic that this symposium will spark intellectual curiosity and interest that will result in lively discussion on the various topics presented. I'd also like to mention Professor Santiago, because this subject plus the other electives under the commercial law, we presented it in the University of Malaga, because this is part of the project funded by the EU and Erasmus under the CALESA, the capability building towards legal and social advancement. So this project has been successful, and the output is for us to have reviewed our curriculum, and so we added a lot of electives, including this one. So please, more of these discussions. Congratulations, Professor Santiago. Congratulations to the pioneer.
Thank you very much.
Okay, thank you, Dean, for that special message. We know you have a busy schedule, but your support means so much to us. We're truly honored to have you with us today.
Yes, and we have another guest of honor whom we're very excited to have with us this afternoon, Justice Rogelio Quevedo. Justice Quevedo's decades of service provides the backdrop for his leadership of the UP College of Law's Commercial Law Cluster. He is currently heading the legal field as the Government Corporate Counsel with prior experience in such varied appointments such as the Office of the Ombudsman, the Presidential Management Staff, the Philippine Council for Foreign Relations, and the Bureau of Immigration, just to name a few. Taking a cue from his time with the private sector, Justice Quevedo's leadership has propelled the OGCC into the future with the use of digital systems to streamline vital processes. This has resulted in a stronger foundation for the country's prime legal institution as it helps uphold the rights of the people through clean and efficient governance. Everyone, please welcome Justice Rogelio Quevedo.
Thank you very much for that very kind introduction. So, good afternoon to our UP College of Law Dean, Dean Lelen Berberabe, whom I believe was already cut off. Believe nga ako sa lakas ng signal ng kanyang internet provider. And of course, to our pioneering Professor Josephine Santiago on this topic, which we at the Commercial Law Cluster had actually also encouraged in accordance with the plan of the UP College of Law to have a minor in human rights. At that time, I was mentioning that there should also be a minor in commercial law. And actually, this subject is the best bridge between the minor in commercial law and the minor in human rights. Actually, the University Council had already approved the minor in human rights, and we are still trying to have the approval of the college towards the minor in commercial law, and thereafter the approval of the University Council. I would like to thank also our project head, Ms. Gaia Michelle Benjamin, professors, of course, Professor Santiago and the UP College of Law Class 194A for inviting me to give a special message to open the symposium on right to life, liberty, and intellectual property, exploring the interplay between intellectual property and human rights. Just at the outset, I would like to mention that the title that I cherish most is the title of professor. That is really what I aimed for in 1986. After my stint with the Office of the President at that time, I went back to the UP College of Law, and at that time was thinking that I would retire as a UP College of Law professor. Fate had it that I would be joining the private sector, where I became where I spent most of my years already. And after having retired from SMART PLDT, I was called again to work in the government sector as the Government Corporate Counsel, being the statutory legal counsel of all government corporations. Let me just mention that although intellectual property experts rarely involve themselves with human rights, alam niyo naman yun, kaya nga yung sabi nila, yung mga nandoon daw sa commercial law and having been emphasized that my background before was in the private sector and having been with PLDT Smart, then human rights law is the farthest from the contemplation of the commercial law professors. Human rights experts also rarely deal with science, technology, and intellectual property. Due to the changing times, however, and I must emphasize artificial intelligence, the legal experts from both sides have started to acknowledge that the interaction between intellectual property and human rights are inevitable. As such, this symposium is a welcome and refreshing topic as an exercise of our legal minds, considering that the field of study on the interaction between human rights and intellectual property rights is young, but especially most important to an emerging economy like the Philippines. As we are all aware, each and one of us, especially in the UP College of Law, enjoy the constitutional guarantees of human rights. That is the right to life, liberty, and property, regardless of race, sex, ethnicity, language, religion, or any other status. On the other hand, intellectual property rights refer to the legal rights given to the creator or inventor to protect his creation and is given to said creator or inventor to have exclusive use of his creation for a certain period of time. Intellectual property is based on economic and growth principles and is given only for a limited period of time, whereas human rights are universal, inalienable, indivisible, and are inherent and enjoyed by each and every one of us. However, as correctly pointed out in the concept note of today's symposium, there are some human rights that may be affected by intellectual property rights, such as not but limited to the person's right to enjoy cultural heritage. The rights of indigenous peoples and local communities, and the right of access to the benefits of science by everyone without discrimination. In my present position, I am confronted now that as government corporate counsel, I have to deal with the indigenous people so that the OGCC has to interact with the National Commission of Indigenous People, the NCIP. We also have to interact with the Presidential Commission on the Urban Poor. That is the reason why the OGCC, whose concentration and which I said was very appropriate for my background as chair of the commercial law cluster, now has to interact with both the National Commission on Indigenous Peoples and the Presidential Commission on the Urban Poor. Projects that we have to undertake, like the Kaliwa Dam, which would actually give better access to water facilities for Metro Manila. Now we have to deal and comply with the requirements of the NCIP and also with the PCUP. Therefore, the commercial law cluster of the UP College of Law, especially with Professor Josephine Santiago, is very much interested to pursue these subjects, which had these 8 subjects, additional subjects in the commercial law cluster to be offered to our classes in the College of Law so that our students would be more exposed not only to the human rights interest, but also be ably grounded also on commercial law. Therefore, without much further ado, I would like to welcome you all, and may we all develop and enhance our knowledge and awareness of the interaction between human rights and intellectual property rights through this symposium. Thank you very much. Good afternoon, Professor Josephine Santiago, and to the class of 194. Probably we will be also offering more subjects as electives and which have already been approved through the efforts of the commercial law cluster. Good afternoon to all of us.
Thank you very much. Thank you very much, Professor Quevedo, for that special message. And we are so glad to have you with us. We are thankful for the opportunity to explore this new frontier as well. And as we have heard from our keynote speakers, the presentations we'll be listening to today are the products of the hard work, the blood, sweat, and tears of the students of IP and human rights.
That's right, Charlie. Through the research of our dear classmates, we get the special opportunity this afternoon to confront various human rights issues pervading the field of intellectual property today. In fact, our first batch of presenters have quite an incisive take on the field of genetic research. Charlie, can we patent life?
Well, we'll find out. Let's now hear from Mr. Uriel Navata and Rolf Villanueva on balancing innovation and ethical stewardship, a discussion on patenting life forms in case of genetically modified organisms, microorganisms for industrial purposes, and human genome editing.
So, good afternoon, everyone. I am Roel Villanueva, and today we're going to explore an increasingly pertinent topic in the global discourse. And this is the intersection of intellectual property rights and human rights. So, welcome to the first topic of today. Focusing on patents, this is balancing innovation and ethical stewardship. And this is a discussion on patenting life forms in cases of genetically modified organisms, microorganisms for industrial purposes, and human genome editing. In recent decades, the conversation around human rights has significantly expanded from its traditional focus on civil and political liberties to include economic, social, and cultural aspects. This expansion has brought to light the important relationship between intellectual property rights and human rights. And this is a topic that has become increasingly relevant and explored. Central to this discourse is the recognition of the right to protect moral and material interests from scientific, literary, or artistic productions as articulated in the Universal Declaration of Human Rights. Moreover, the so-called right to science, enshrined also, has begun to capture global attention. This right encompasses not only the protection of moral and material interests resulting from the intellectual production, but also the broader entitlement to enjoy the benefits of scientific progress and its applications. This evolving understanding emphasizes not only the protection of creators' rights, but also the broader public's right to benefit from scientific progress and its applications. So, we give you an overview of what we're going to discuss here today. First would be the genetically modified organisms. And the patent law surrounding these GMOs presents a complex landscape, particularly highlighting the challenges faced by farmers who may unknowingly infringe on patents. This is in the case of Monsanto and Pfizer, and this illustrates how individuals can be legally implicated without intent, as the mere presence of a patented gene in crops, regardless of how it arrived there, can lead to infringement claims. This legal standpoint does not require proof of intent for infringement, placing a significant burden on farmers who might unknowingly cultivate patented GMOs due to natural phenomena like cross-pollination. While GMOs offer substantial environmental and health benefits, such as reduced pesticide use and potential for enhanced crop traits, the public actually remains divided over their use. And these situations underscore the necessity for a more balanced approach in patent law that aligns the rights of inventors with wider goals of scientific progress and public welfare, particularly in the context of global food security and sustainable development. Next would be the microorganisms in industrial applications. As we can see, the Budapest Treaty, overseen by the WIPO, simplifies patent disclosure for microorganisms by recognizing a single depository. And the TRIPS agreement under the WTO mandates patents in all technology fields, but allows exclusion of plants and animals, but not microorganisms. This diverse legal framework, coupled with the absence of a universal definition of what a microorganism is, results in varied interpretations and applications of patent law across differing countries. For example, in the landmark case from the US, Diamond and Chakrabarty, this has propelled the patent system towards a more liberal stance, fostering biotechnological growth. Because in this case, it acknowledges that anything under the sun that is made by man is patentable. And in the European patent system, while similar in its treatment of biotechnologies, includes a public order and morality clause. And this is exemplified in the Harvard OncoMouse case, and it is aimed to assess the potential benefits of a claimed invention against the negative aspects. For example, considerations could be taken into account in the balancing tests, such as environmental risks or public unease, and also the moral disapproval of the populace and also those researching themselves. So it was concluded here that the usefulness of the oncomouse in furthering cancer research satisfied the likelihood of substantial medical benefit and outweighed the moral concerns about suffering caused to the animal. And lastly, the human genome editing and designer babies. So we, of course, have knowledge of this already and how it might be triggering to ethical debates because the legal regulation of embryo editing is essential due to its significant benefits, but also coupled with its significant risks. This includes the potential to treat genetic diseases and the danger of misuse leading to social inequalities and eugenic practices. So the CRISPR technology, introduced for embryo editing in 2015, offers this precise gene alteration, but raises concerns about safety, effectiveness, ethical implications, and especially implications regarding future generations. And the prospect of creating designer babies blurs therapeutic and enhancement boundaries in genetic engineering, thus raising fears of social division and discrimination. Critics, of course, argue about the ethical implications of using embryo editing for human enhancement. And international bodies like UNESCO's International Bioethics Committee advocate restricting genome editing to specific purposes like to maintain human dignity and prevent the revival of eugenic practices.
Good afternoon, everyone. My name is Uriel Navata, and for the first discussion, I'd like to talk about global food security and farmer autonomy. So, to get started, let's have a look at an overview of genetically modified crops. Genetically modified crops, or GM crops, have been developed and grown since the 1990s and are created through the process of genetic engineering, where the DNA of an organism is modified to produce desirable traits. The traits are sought for specific purposes, such as to increase yield, increase food production, reduce the need for pesticides and other harmful chemicals, and to produce a highly nutritional crop to address nutritional deficiencies in certain populations. The Philippines is one of the countries where genetically modified crops are being grown and used, and to ensure safety and prevent negative environmental impact, genetically modified crops in the Philippines are regulated by the Department of Agriculture. Also, evaluation of GM crops is supervised by several government agencies before approval for commercial purposes. So, despite the comprehensive evaluations and assessments that they undergo, GM crops have remained a controversial topic in the Philippines. Some groups say that they can help increase food security and boost the country's agricultural sector, while others express concerns over potential environmental and health risks. Regardless of the ongoing debate, the government has approved some of the GMOs that are considered safe for human consumption and the environment. So these include BT eggplant, BT corn, and golden rice, also known as malusog rice. So how do GM crops actually affect yields and production? It was found that, on average, GM crops increase agricultural yield by 22%. The global food crop yield from 1996 to 2013 has increased by over 370 million tons. And GM crops have also reduced pesticide usage by 37% and environmental impact by 18%. So to achieve the same yield standards, more than 300 million acres of conventional crops would have been needed. And this would aggravate current environmental and socioeconomic problems in agriculture. Now, what existing issue would that migrate? Evidently, food security, which exists when people have physical and economic access to sufficient, safe, and nutritious food. Unfortunately, around 900 million people are undernourished. So according to a 2013 study, GM crops may actually help alleviate problems regarding food security. Using BT cotton, which is a genetically modified pest-resistant plant cotton that provides resistance to pests. It reduced chemical pesticide use and increased the yield of crops. And the research showed that the gains from adopting BT cotton had positive effects on calorie consumption and dietary quality. Of course, GM crops are not meant to completely solve the global undernourishment problem. However, there is evidence to suggest that they could play a key role in attaining food security for everyone. So now moving on to farmer autonomy and seed ownership. Let's examine the problems when it comes to patenting seeds and farmers' rights. Plants have been deliberately bred for over 10,000 years, but IP law has only been applied to the seed system for less than a century. And in 1980, the case mentioned by Barry earlier, the US Supreme Court case, Diamond versus Chakraborty, uh, concerned genetically engineered microorganisms, and there the court ruled that anything man-made under the sun was eligible for a patent, which included living organisms. So in the years following that decision, utility patents on plants have been used as a mechanism to consolidate power in the seed industry. So major companies, including corporate giant Monsanto and plant variety developers, have capitalized on restrictive intellectual property claims in defending the rights to seeds and genetic traits. Thus, this led to reduced genetic diversity and a disregard for traits essential to a sustainable food system. In fact, they have created a market structure in which just 4 companies control 60% of the world's seed stock. So restricting access to seeds is only one way the patent system works to narrow crop genetic diversity. Patented seeds also have the potential to contaminate farmers' varieties whose traits are carefully preserved. Some seed growers, particularly those involved in indigenous or culturally important varieties, have expressed that they are not afraid of the patenting of their varieties by other seed growers as much as they are of genetically engineered and patented traits contaminating their crops through cross-pollination or accidental contamination. So, apart from the fact that their carefully grown crops could be damaged by accidental contamination, another reason why farmers may be afraid of GM crops crossbreeding with theirs is likely due to the case of Monsanto versus Schmeisser in 1998, which dealt with the following question: can farmers be sued for unknowingly using patented seed? The court in this case ruled that Schmeisser was guilty of patent infringement, and in 2012, it was found that Monsanto had filed 142 patent infringement suits against small farmers, and that it had been awarded over $20 million in total. Thus, this created a burden for seed growers to actively avoid cross-contamination, especially with GM crops. So in addition to this problem created by the current system of patenting of plants, license restrictions also prohibit research or experimentation and the growing of GM crops for research purposes. Evidently, no research clauses may pose a threat to public health and safety since they directly involve the food supply. In spite of the studies conducted since GM crops were first introduced, the possible health consequences of genetically modified foods, particularly long-term consequences, are to a certain extent still unknown, as there is an information void where we do not have enough information to determine the extent of unintended health and environmental consequences. For Elizabeth Rowe of the University of Florida, Levin College of Law, these are the results of patent overreaching, where the protection granted to the patenting of plants is beyond that which was intended. So she proposed to create a judicial doctrine to be used by courts when determining whether certain restrictions are within a patent right to ensure that public interest is directly considered. In the case of genetically modified foods, the license agreements create cause for concern, and it reflects another example of intellectual property laws providing far greater protection than contract law alone would provide in a typical sense. Rowe explains that courts could rely on a patent overreach doctrine in refusing to enforce license agreements that restrict research. The patent overreach doctrine is also consistent with the doctrine of patent misuse, which forbids an impermissible broadening of a patent beyond the scope of the rights. So she suggested a possible iteration of the patent overreach doctrine, which could be an expansion of the patent misuse doctrine to cover conduct that goes beyond the scope of a patent, which is contrary to public interest, such as undue restrictions on scientific research. Finally, Rowe contends that the public interest in promoting independent research on the health and safety effects of foods should outweigh the patent holder's interest in controlling the state of adverse information available about the product. In a report to the UN General Assembly by Special Rapporteur Olivier de Schutter, he claims that professionalization of breeding and its separation from farming leads to an emergence of a commercial seed system alongside the farmers' traditional seed systems. But the poorest farmers may become increasingly dependent on expensive inputs, which would create a risk of indebtedness. And in that same report, the Shutter also proposes using a human rights framework with respect to policies and IP rights concerning seeds um, that should be used to determine who should benefit from gains by the policies put in place. In connection with that, he emphasizes the importance of Article 11 of the ICE-SCR, which imposes on states three levels of obligations in the realization of the right to food. So these are the obligation to respect existing access to food, protect and fulfill the right to food. Another solution that the shooter put forward is to consider using antitrust legislation in order to combat excessive concentration in the providers market. So this entails the risk of abuse by dominant seed companies through the setting of prices at levels which may be unjustifiably high for poor farmers. And he also advanced the idea that states should ensure that protection of patent holders' rights does not encourage innovation in the name of enforcing said rights, such as by allowing research exemptions for states that allow patents on plants. Now, what are the challenges to traditional farming practices? Patents may also inhibit farmers' traditional farming practices of using, exchanging, and selling farm-saved seeds that contains patented material. Because traditionally, farmers save portions of seeds from their crops to plant the following year or to trade with other farmers. And this practice is referred to as farmers' rights. However, if there's a patent on the seed that the farmer has grown, especially if it's genetically modified, the farmer may be prevented from saving the seed. So to continue to grow patented crops, farmers are often required to sign a technology agreement in which they acknowledge that saving or selling the seeds is prohibited. So major concerns for uh, uh, major concerns are that farmers are also constrained to annually purchase their seed from a biotech company rather than other farmers and local seed companies. And another challenge that farmers face is the fact that lawsuits against farmers for saving seeds have actually been successful. Uh, uh, can you go next slide, please? So environmental consequences have also been raised by critics of GM crops. There's the unintended crossbreeding of GM crops with non-GMO crops. Um, it there's the concern that this would um reduce in the result in the reduction of wild plant varieties, which leads to the next topic, which is an effect on biodiversity. Concern for GMOs is that they will reduce genetic diversity in the environment. Some groups are concerned that if modified genes are introduced into wild plant populations, they could mean that hybrid species would be able to better reproduce, and thus the wild species would eventually die off.
Okay, now starting the discussion on microorganisms. And this is patenting synthetic microorganisms. The landmark decisions of Berge and Chakrabarty by the Court of Customs and Patent Appeals, or the CCPA, have significantly influenced the understanding of microorganism patentability. This challenges the traditional products of nature, quote unquote, doctrine. This doctrine, often invoked in court decisions, suggested that naturally occurring substances were not patentable. However, a deeper examination of case law reveals a more nuanced application. For instance, contrasting rulings in cases like General Electric and Parker Davis. These rulings demonstrate that the court struggled with this doctrine. And the former case saw the invalidation of a patent for substantially pure tungsten categorized as a natural product, whereas the latter upheld a patent for adrenaline, which is extracted and purified from animal glands, recognizing it as a distinct composition from its natural form. So in 1980, the case of Chakrabarty allows the patenting of living organisms or living microorganisms, marked marked this as a pivotal change in intellectual property law because the term microorganism now covers a wide array of biological materials, causing also some legal ambiguity. This category includes viruses, bacteria, yeasts, fungi, and more, extending even to genetic engineering tools. And the European Union sought to clarify this by defining biological material as any genetic information containing material capable of self-replication or reproduction in a biological system. Globally, feedback from 16 countries, which also includes the Philippines, shows a consensus on the patentability of microorganisms based on their novelty, inventiveness, and industrial applicability, with varying approaches to the patenting of genetically modified organisms and their underlying genes. Next, we go into the ethical implications of the patents on microorganisms. Judge Rich argued that microorganisms, due to their utility and technological significance, should not be excluded from patent protection merely because they are quote unquote alive. He deemed the differentiation between microorganisms and chemical compounds based on the former's animateness as legally irrelevant. This perspective finds indirect support in existing case law. The CCPA in Arsberger, for instance, highlighted the disparity between the scientific and conventional meanings of terms like plants. Extending this logic, it can be contended that microorganisms, though they are living in a broad scientific context, might not be considered living in the more restrictive everyday or patent law sense. So, as quoted, microorganisms were a useful and technological art. Judge Rich felt that they should not be denied patent protection on the formalistic ground that they were quote unquote alive. And this ongoing debate highlights the challenges in adapting patent law to rapidly advancing technological fields. Some legal experts advocate for a strict interpretation of patentable subject matter, limiting it to inventions similar to conventional technology, while others favor a more liberal approach, including a broader range of new and useful inventions. And this division underscores the need for patent law to evolve in response to technological advancements. And of course, the evolving nature of patent law in the context of biotechnological innovation and the broader implications for intellectual property rights in the field of living organisms. Now, lastly, we go to the impacts in society, environment, and the economy. So, microbial stains, particularly fungi, are increasingly being used in bioremediation to treat industrial wastewater and remediate environmental pollution. These living organisms break down toxic chemicals in polluted environments, offering an eco-friendly and effective solution for soil contamination. And the field of technology is focusing on enhancing the enzymatic and metabolic processes of fungi for large-scale commercial applications and genetic engineering. This has led to a surge in scientific research and patent applications, particularly in the area of soil bioremediation for agrochemicals. Next would be the shift in wealth generation from physical assets to knowledge and information has actually made profound implications for the ownership and control of genetic resources. Historically linked to land ownership, wealth generation now increasingly depends on intellectual property rights, particularly patents on products derived from genetic resources. And now this would lead into the problem of tragedy of the commons. These resources, mainly found in lesser developed countries, have become valuable economic assets but face rapid destruction due to the international legal system that promotes their consumption in lesser developed countries. Developed countries, in contrast, benefit from the conservation and commercialization of these resources. And this situation is often referred to as the tragedy of the commons because this creates a divide in the debate over the fairness of granting property rights to industrialists for fostering innovation versus the exploitation of lesser developed countries who are the primary sources of these resources. Now, for the next topic.
Now let's move on to the topic of editing the human genome. So, genome editing technologies enable scientists to make changes to DNA, leading to changes in physical traits like eye color and disease risk. So, scientists use different technologies, which cut the DNA at a specific spot, then they can remove, add, or replace the DNA where it was cut. So, First developed in the late 1900s, genome editing is mainly used for biological research and medical purposes. And a new genome editing tool called CRISPR has made it to even easier to edit DNA. Um, so application of genome editing have raised scientific, safety, ethical, and policy concerns. In fact, human genome editing is largely forbidden by laws or guidelines, even in countries where human embryonic stem cell research is allowed. Um, this poses a few questions. For example, is it okay to use gene therapy on an embryo when it is impossible to get permission from the embryo? So is getting permission from the parents enough? Um, what if gene therapies are too expensive and only wealthy people can access them? Then that would worsen existing inequalities between the rich and the poor. Um, will some people use genome editing traits for those that are not for health, such as athletic ability or height? Would that be okay? And should scientists ever be able to edit germline cells? Germline cells are those that would be passed down through generations. So this would affect not just the current embryo, but also future generations. Um, Many in the scientific community credit the discovery of CRISPR to Jennifer Doudna and Emmanuel Charpentier. Um, so they filed a patent application for the technology in May 2012, but a team led by Feng Zhang of the Broad Institute of MIT and Harvard filed another patent application for CRISPR 7 months later. And as of now, the Broad Institute appears to be victorious. The courts have widely upheld their initial patent and have determined that the Broad Institute has priority. Uh, since CRISPR's basic technology is subject to numerous foundational patents, many of which are licensed by biotechnology and pharmaceutical companies, um, those patents would allow therapeutic developers to control how CRISPR will be developed into therapies and the prices charged to distribute them. And without some form of intellectual property protection, therapeutics companies cannot charge the sort of competitive prices that generate profits. And this patent-based system of therapeutic research and development has both positive and negative consequences for public health. Generally, therapeutic developers, of course, have strong interests to develop therapeutics affecting the greatest number of people. As an example, rare diseases are unfortunately typically under-researched. Um, by definition, the therapeutic market for rare diseases is smaller, and therapeutic developers have fewer incentives to cure or treat patients suffering from them. So scientists are developing gene therapies, treatments involving genome editing to prevent and treat diseases in humans. In 2015, in fact, scientists successfully used somatic gene therapy when a 1-year-old in the United Kingdom named Layla received a gene editing treatment to help fight her leukemia. Now, a curious topic that CRISPR may have with interactions with that may have interactions with is that of designer babies. Designer babies are genetically engineered babies in vitro for specially selected traits to lower the risk of disease. So critics are concerned that it will eventually lead to a market for designer babies, children whose traits are pre-selected by parent consumers. In November 2018, Chinese scientist He Jiankui announced that he had used CRISPR technique to create the first genome edited baby. Of course, some ethical concerns held by opponents of designer babies are related to the social implications of creating children with preferred traits. Um, the social argument is that if this technology becomes realistic and accessible, and becomes an accessible medical practice, then it would create a division between those that can afford the service and those that cannot. Therefore, the wealthy would be able to afford the selection of desirable traits in their offspring, while those of lower socioeconomic standing would not be able to access the same options. And economic divisions may grow into genetic divisions, with social distinctions delineating enhanced individuals from unenhanced individuals. It's also possible that the use of CRISPR can introduce collateral damage. Um, Creating a child by genetically editing an embryo may be risky and might produce damaged children. On the other hand, if the procedure can be proven safe and effective, It can be argued that the limited use of gene editing purely for medical purposes is actually the ethical thing to do. So in cases, for example, where a woman's eggs have a heritable genetic abnormality, um, or both she and her husband have recessive genes linked to a disease, gene editing could, in theory, result in a healthy offspring. So other bioethicists have also argued that parents have a right to reproductive autonomy, which grants them the right to decide the fate of their children. And according to this argument, parents should be able to employ whatever methods are available to them at whatever expense, um, to have a baby of their desire with whatever physical, intellectual, or psychological traits they believe can be offered to the offspring. So under this view, governments should not set limits or dictate the rights of parents with respect to reproductive autonomy. Lastly, Article 11 of the human of uh, the Universal Declaration of the Human Genome and Human Rights provides that practices which are contrary to human dignity, such as reproductive cloning of human beings, shall not be permitted. Gene editing could be exactly the kind of practice that Article 11 intends to cover, but one argument against it is that the language in the first sentence is extremely broad, prohibiting undefined practices if they are contrary to human dignity. So rather than relying on an ambiguous interpretation, UNESCO can revise Article 11 to contain an explicit provision prohibiting gene editing to eliminate any ambiguity among the international consensus. This solution would ensure that ethical obligations will not unnecessarily hinder science, but also that the international research community will not take them lightly.
So to close it off, the research on patenting life forms, including GMOs, microorganisms, and human genome editing, highlights the critical need to balance technological innovation with ethical stewardship. This emphasizes the importance of stringent ethical guidelines and a robust legal framework to ensure that scientific advancements must align with human rights and also environmental integrity. Thank you everyone for listening, and I hope that you all have been primed for what we have more in store today.
All right. Thank you so much, Uriel and Ruel, for your fascinating presentation on balancing innovation and ethical stewardship in genetic research. We're really glad as well to see our audience members weigh in through our Zoom chat feature. So throughout our presentations, feel free to send in your thoughts and we'll try to respond to all of them by the end of the program.
Yes, and Therese, while I was watching Uriel and Roel's presentation, especially in the subject of embryo editing, there's this quote by writer Michael Crichton that came to mind.
Charlie, Michael Crichton, the author of Jurassic Park, right?
Yes, the one and only, the one who made us all dream that dinosaurs can be clones or genome editing, and we all know how that turned out.
Yes.
He wrote that biotechnology promises the greatest revolution in human history, and by the end of this decade, it will have outdistanced atomic power and computers in its effect on our daily lives. And it's going to be in everyone's hands.
Well, that's not too far off from what's actually happening right
Yes.
now. So there you have it, everyone. If anyone among our audience members have any questions for our presenters, please send them in through the Q&A button, and we will try to answer them during our Q&A portion later on.
Yep, and we only have a limited time for our Q&A, but we will try our best to go through everyone's questions.
Okay, in the meantime, let's move on now to our next presenter who poses an inquiry, this time into protecting Indigenous peoples' IP rights.
Yes, IP for IP.
Exactly. Let's hear from Ms. Gaia Benjamin on protecting living knowledge challenges to protecting genetic resources and associated traditional knowledge, or GRATK, in Philippine patent law.
Good evening, everyone. The Philippines is globally recognized as a mega biodiverse hotspot, a treasure trove of ecology. However, beneath this natural wealth lies a complex issue: the exploitation of biodiversity and traditional knowledge of indigenous peoples by multinational corporations. This not only threatens the country's ecology, but also undermines the cultural rights of indigenous cultural communities, or ICCs, and impact their human dignity and ultimately their cultural survival. Neglected as they are, cultural rights are human rights. The protection of traditional knowledge is both an intellectual property and human rights issue. The rights granted to ICCs under Article 31 of the UN DRIP empower them not only to safeguard their traditional knowledge, but also to control, protect, and develop their intellectual property related to such knowledge. The Convention on Biological Diversity, or CBD, essentially defines genetic resources as biological material that has or could have value. These include things like medicinal plants, animal toxins, microbes in the soil, and even our blood. On the other hand, traditional knowledge, or TK, is broadly defined by the World Intellectual Property Organization as a living body of knowledge passed down through generations within a community and covers diverse areas like agriculture, science, technology, ecology, and medicine, and many more. Of significance is the intersection between genetic resource and traditional knowledge, with some genetic resources being intricately linked to associated traditional knowledge. The distinction between genetic resources and associated traditional knowledge is important, as the permission to access genetic resources does not necessarily imply permission to use associated knowledge and vice versa, as per Article 37 of the CBD Bond Guidelines. The insidious practice of biopiracy exemplifies this disconnect. Researchers representing multinational corporations visit ICCs, document their traditional knowledge, and exploit their GRATK without obtaining free, prior, and informed consent. This knowledge is then commercialized, patented, and monetized by these corporations, resulting in substantial profits without due recognition or compensation to the indigenous communities. An illustrative case is the banaba, known for its medicinal properties by the ICCs of Benguet Province, among other places. Although not exclusive to the Philippines, patents for the plant's properties have been granted to foreign corporations like Japan and the US, countries where the plant cannot be found, again, with no consent or benefit to the indigenous populations. According to a 2004 UNDP report, at least 7,000 patents had been granted for the unauthorized use of traditional knowledge, a stark illustration of the pervasive nature of this problem. How many more have been granted since then? Beyond monetary implications, biopiracy perpetuates the erasure of ICC's identities and violates their human dignity. For these communities, it's not just about financial compensation. It's a matter of cultural survival. At first glance, the Philippines has a strong legal framework for the protection of GRATK. We have IPRA, EO247, and multiple administrative issuances that prescribe the guidelines for corporations and researchers, both local and foreign, to access and make use of the GRATKs, all of which expressly require the free, prior, and informed consent of ICCs before bioprospecting can be done. That is, the research, collection, utilization of biological and genetic resources for purposes of applying the knowledge derived therefrom solely for commercial purposes. That is the definition of bioprospecting. They even provide for penalties and require memorandum of agreements to contain clauses for equitable sharing of access and benefits. In patent applications, mandatory disclosure of indigenous sources is also required. However, several issues still remain. These laws all fail to enumerate concrete protective measures and lack monitoring and enforcement mechanisms. The patent system demands novelty, non-obvious inventive steps, and industrial applicability, making it ill-suited for the timeless and communal nature of traditional knowledge. Moreover, patents are valid for only 20 years, contradicting the perpetuity inherent in traditional knowledge. Alternatively, a sui generis system specifically tailored for the protection of TK would offer perpetual protection. The implementation of the CBD and its Nagoya Protocol, which the Philippines acceded to in 2015, aligns with the sui generis approach. The Nagoya Protocol establishes a legal framework that aims for the fair and equitable sharing of benefits arising from the use of genetic resources. However, despite commitments, the Nagoya Protocol's effective implementation remains elusive. Initiatives like the DENR's ABS project and proposed bills, including Senate Bill number 2167 of the 7th Congress, indicate progress but also pose lingering questions. 17th Congress. Determining the scope of protected GRATK also raises challenges. The WIPO Intergovernmental Committee on Intellectual Property and GRTK and Folklore, or IGC, delegates the specific determination of protectable subject matter boundaries to individual countries. Striking the right balance is crucial. Too broad a scope could expose GR80K to potential misuse, while overly narrow definitions may render protections ineffective. Another aspect requiring consideration is the determination of exceptions. South Korea, for instance, simplifies or waives procedures if there is a need for expeditious access to or utilization of genetic resources. The meaning of such exemptions and their applicability needs clarification. Defining traditional knowledge is also important for effective protection. Tradition in this context does not mean old, but rather knowledge associated with local communities and indigenous peoples. Ethnobotanical databases, GR80K registries, and other similar measures can play a pivotal role in maintaining specificity and aiding in the protection of GR80K. But even those have challenges, as can be seen from the questions on the screen. In conclusion, the challenge lies in striking a delicate balance between protecting indigenous cultural heritage, ensuring the rights of ICCs, and fostering innovation. Whether through amendments within the existing IP system or the establishment of a sui generis system, answering critical questions surrounding the scope, exceptions, and specifics of traditional knowledge is imperative. As the Philippines navigate these complexities, the goal remains to be the equitable protection of its rich biodiversity and the preservation of the cultural legacy of its indigenous communities. Thank you for listening.
All right. Thank you very much, Gaia, for your presentation. And it's definitely high time that IP law should be balanced in favor of indigenous people's rights. Don't you think so, Therese?
Definitely. Of course, as Gaia has shown through her presentation, we've still got a long way to go to iron out all these issues surrounding indigenous intellectual property.
Right. And well, you know what they say, the wheels of justice grind slow, but it grinds exceedingly fine.
That's right. Now we go to our next batch of presenters, and boy, are they raising an issue that hits very close to home. Charlie, when was the last time you needed medicine?
Just before this event, actually.
Talaga?
Yeah.
What did you need it for?
Just before we went on air, I was so nervous. Had to take a chill pill.
Okay, wag na natin alamin kung anong klaseng chill pill yan. What's important right now is we understand how patent law actually plays an important role in our access to essential medicines.
Yes, and with that, ladies and gentlemen, please welcome Miss Angelica Bautista and Miss Yvette Morales for their presentation, Balancing Pharmaceutical Patents and Access to Essential Medicine, an analysis of domestic laws, international agreements, and Philippine jurisprudence in the context of the COVID-19 pandemic.
Hello, good afternoon. So, my name is Angelica A. Bautista, and I will be speaking about the intersection between pharmaceutical patent rights and the human right to health in the Philippines in light of the COVID-19 pandemic. So, this study identifies issues in the international agreements, particularly TRIPS agreement, corresponding domestic laws and jurisprudence which affect the Philippine pharmaceutical industry in terms of the public's access to essential medicines. It also aims to explore how pharmaceutical industries exploit intellectual property laws through trade secret protection. And consequently, the paper will suggest solutions and recommendations to prevent dominant pharmaceutical companies and vaccine developers from profiteering and maximizing their IP rights, especially during a public health crisis such as the COVID-19 pandemic. So first, we need to ask, previous slide, please. So, what is the relationship between international human rights law and international IP or trade law? So, the acknowledgement of the right to health as a fundamental human right is evident in numerous international legal agreements, including the UDHR, the Universal Declaration of Human Rights, and the International Covenant on Economic, Social, and Cultural Rights. The human right to health encompasses the right to access essential medicines, and governments have a responsibility to take steps to ensure that medicines are available, accessible, and affordable. On the other hand, the TRIPS agreement, or the trade-related aspects of intellectual property rights, is an existing global structure in order to safeguard IP rights, and it aims to reduce obstacles to international trade. The underlying principle behind such protection is to foster innovation. So this involves incentivizing the development and disclosure of pharmaceutical products and other medical technologies. Patent rights play a crucial role in reinforcing ownership by guaranteeing a return on investment. They achieve this by providing exclusive rights over the invention for a limited period and safeguarding data derived from research and development. So, what makes TRIPS agreement unique is the transformation of the international intellectual property protection to hard law, because it not only mandates the Trade Organization member states to implement enforcement mechanisms for IP rights, but it also links intellectual property protection to the dispute settlement of the WTO, which provides compulsory and binding mechanism in order to resolve IP disputes. So, crucially, the TRIPS agreement recognizes that intellectual property rights should serve a broader public interest. Article 8 of the TRIPS agreement explicitly acknowledges the right of WTO members to adopt measures to protect public health and nutrition in order to prevent the abuse of intellectual property rights, as long as such measures are consistent with the provisions of the TRIPS agreement. In its provisions regulating the protection of patents and undisclosed information, Article 39, the TRIPS agreement also establishes standards for the scope and applicability of patent rights, particularly in fields like pharmaceuticals. So while patents under TRIPS provide exclusive rights for a minimum term of 20 years, exceptions and flexibilities under Articles 30 and 31 of the TRIPS agreement are introduced to address public interests. However, it is essential to note that the TRIPS agreement has faced criticism for not adequately addressing the problems and special needs of developing countries, such as the Philippines. The exclusive rights granted by pharmaceutical patents, for example, have been perceived as potentially impinging upon the pricing of medical products, particularly in LDCs or with high levels of poverty. Therefore, the TRIPS agreement posed challenges to the realization of the human right to health, particularly in developing nations where pharmaceutical products are often priced beyond the means of economically disadvantaged patients. So, next slide, please. The issue now is the issue to be resolved then is the fact that while the TRIPS agreement and the Doha Declaration explicitly address the importance of public health, there is a lack of distinct hierarchy between trade law and human rights law. So, which one is superior? Another question arises whether IP rights should also be recognized as human rights. After all, the UDHR and the ICSCR also vaguely allude to the protection of scientific, literary, or artistic production, suggesting that there is a potential human right to intellectual property. So two main perspectives emerge regarding the classification of IP rights as human rights. Some people argue that IP rights protecting private interests are fundamentally at odds with the public law character of human rights, because IP rights are limited in duration and is subject to registration. Moreover, patent holders are often corporations rather than individual inventors. So this also raises the question of whether corporations can be beneficiaries of human rights, given that human rights are inherently tied to human dignity and the equal worth of individuals. Others, on the other hand, contend that IP and human rights are interconnected, especially in recognizing IP as an extension of the human right to property. So it is noted that if patents are granted, they may be regarded as regular property and protected under the human right to property. So what then is the answer to this question? So we argue that it is not. So while IP rights play a role in incentivizing creativity, they are fundamentally instrumental and they differ from human rights because human rights derive from the human person. Moreover, the protection of tangible property differs significantly from the protection of IP because it safeguards knowledge, which is an unlimited and non-contentious resource. So in the global context, answering the question as to the distinction between fundamental human rights and IP is very crucial because there is a danger in elevating IP rights to a human rights standard, especially since the latter mainly protect business interests rather than individual creators. Next slide, please. So the proposed solution that we have uh, we tried to solve the question. So the TRIPS agreement should explicitly establish that the TRIPS agreement shall not contravene human rights standards. So as an example, an amendment to the provision may be that International Bill of Rights, which encompass the UDHR, ICSR, and ICCPR, among other human rights treaties, should act as valid limitations to the IP rights of TRIPS and not mere exceptions to the rule. Next slide, please. So another critical issue that was further eliminated during the pandemic is the pharmaceutical industry's exploitation of IP laws by opting for trade secret protection or mixed trade secret and patent protection. So what are trade secrets and how are they used to circumvent IP laws? Next slide, please. So while a patent is a legal right of protection provided for new, useful, and non-obvious inventions, trade secrets refers to confidential business information that provides a competitive advantage. In order to obtain patent, an inventor must first file a patent application with the relevant government patent office. The application is subject to examination and the patent is granted if the invention meets a specific criteria. Trade secret protection, on the other hand, is not obtained through a formal registration process. Unlike patents, which are publicly disclosed and can be accessed by anyone, once the patent is granted, trade secrets involve confidential information safeguarded by companies to retain a competitive advantage. So it relies on the maintenance of secrecy. And so companies must take reasonable steps to keep the information confidential. In terms of duration protection, patents are granted by the government, giving the patent holder exclusive rights to their invention for a limited period, generally 20 years from the filing date, after which the invention enters the public domain, and others can freely use, make, or sell the patented invention. On the other hand, trade secret protection can potentially last indefinitely as long as the information remains confidential and is not publicly disclosed to the exclusion of the situation where the information becomes known or when it is independently discovered by others, in which case trade secrets lose their protection. So what is an example of a trade secret? Next slide, please. So consider Coca-Cola, for example. So Coca-Cola, instead of filing for a patent in 1885, which would have made the recipe available for other manufacturers to imitate after its patent expiration, the company chose to keep the formula confidential, thus preserving its monopoly for over 130 years. The challenge arises when this is applied within the pharmaceutical industry. So for example, at the height of the pandemic, the mRNA Technology Transfer Hub, in the hopes of revolutionizing vaccine accessibility, initiated by the World Health Organization in South Africa, successfully developed a lab-scale COVID-19 mRNA vaccine, reverse engineered from Moderna's vaccine, and is preparing for clinical trials. Its primary objective is to transfer the cutting-edge technology to low and middle-income countries. The primary beneficiaries of the WHO's mRNA initiative. So this empowers them to manufacture their own vaccines and prepare them for future pandemics and public health emergencies. However, Moderna has been hesitant to disclose its comprehensive information, including its vaccine formula, manufacturing processes, quality control procedures, and other technical know-how not encompassed by its patent. So the absence of the critical information or the trade secret presents a significant hurdle to the hub's mission to democratize mRNA vaccine technology because It delays vaccine production and perpetuates global health disparities. Moderna's refusal to disclose its trade secrets is supported by a provision in the TRIPS agreement, which mandates the protection of undisclosed information. And next slide, please. Article 39, paragraph 2 stipulates that natural and legal persons shall have the possibility of preventing information lawfully within their control from being disclosed to, acquired by, or used by others without their consent in a manner contrary to honest commercial practices. Next slide, please. So in the case of the Philippines, undisclosed information is also protected under the Intellectual Property Code, Section 4.1. However, the Intellectual Property Code did not give a definition of trade secrets. The definition is, however, provided in jurisprudence, Air Philippines Corporation versus Penswell Incorporated. So in the case, it was held that trade secrets constitute proprietary rights. The inventor, discoverer, or possessor of a trade secret or similar innovation has rights therein which may be treated as property, and ordinarily an injunction will be granted to prevent the disclosure of the trade secret by one who obtained the information in confidence or through a confidential relationship. It is also penalized in the revised penal. So another example is Roche Diagnostics. So in March 2020, a Swiss multinational pharmaceutical and diagnostics company fell short in supplying Dutch laboratories the materials needed for coronavirus testing, and they only met 30% of the demands of the market. Now, the Dutch government compelled the disclosure of the lysis buffer recipe, a solution utilized for breaking down cells, and is crucial in manufacturing laboratory materials for COVID-19 testing through a compulsory license. However, Roche refused, as apparently it is not protected under a patent but a trade secret. It instead recommended that the Dutch government limit its testing. So, despite government pressure, it only released an outdated version of the recipe, rendering it unusable for contemporary laboratory needs. So, this discrepancy arises because while the TRIPS agreement offers flexibility such as compulsory licensing to patent-protected inventions, there's a notable absence of a parallel mechanism or a similar mechanism for trade secrets. So, next slide, please. So this is our proposed solution. Amendments to the protection of undisclosed information under Article 39 should be considered, particularly the imposition of sanctions to prevent improper resort to trade secret protection. So it may also be beneficial to develop balancing tests which prioritize the release of trade secrets when the public interest outweighs the potential private harm. It would also be beneficial to enact Philippine legislation concerning trade secret protection. While Philippine jurisprudence held that trade secrets are exempt from compulsory disclosure in line with the right of the people to information, it also asserted that such privilege is not absolute, especially when it is indispensable to do justice and compelling reasons are faced. Still, the problem remains, and that aside from the protection granted under Section 4.1 of the IP Code, there is still no legislation concerning trade secret protection. So that's it for my part. Now I give the
All right, thank you so much, Angelica, for your critique of our prevailing IP laws both here in the Philippines and on the international domain. But before we go to Yvette's presentation, I just want to share that this topic really hits close to home, and I know that I'm not the only one here who feels that way. Charlie, do you remember getting access to vaccines during the pandemic? I wasn't in the country, but how was it for you and your family? Did you have a hard time at all getting vaccinated?
Actually, for us stuck in quarantine back then, it was a pretty nail-biting affair since for some time we weren't sure how the vaccines would come, how they would be disseminated to the public. I guess because of a certain flexibility in the concept of intellectual property in the first place. In case of vaccines, we were able to get them along with the rest of the world.
Yes, and there were so many issues more than just vaccine acquisition. Like you said, there's also dissemination, and aside from that, I know there was also an issue on the maintenance of vaccines. I know that governments, local governments had a hard time taking care to store them in the proper environment
Mhm.
so they aren't expired. And yeah, that all plays into the public's access to these essential medicines during such a crucial time. So yeah, when I just want to share my own personal experience with that, because during the pandemic, I spent some time in England, and I could really tell the difference from the stories that my family members were from back here were telling me that they were having quite a hard time getting access to vaccines over here. But in England, it was you could really tell the difference from like a first world perspective, I guess. There was an abundance of vaccines, at least in our area. Not really, I didn't hear any complaints about people not getting vaccinated.
Mhm.
In fact, there was more of a concern about how they didn't want to get vaccinated over there. So that's quite the another contentious issue
Yeah,
regarding vaccines.
yeah. So there's
All
still a
right.
difference between the global north and south, right?
Yes, definitely. And that's another political issue that we have to grapple with. All right. So I want to hear more about access to medicines. Let's hear now from Yvette on her presentation. Free for
You.
all, a look at the WTO COVID-19 patent waiver.
Thank you, Therese and Charlie. So good evening, everyone. So I'm Yvette B. Morales, and I'll be presenting my research on the COVID-19 patent waiver, which will help contextualize the laws, treaties, and concepts previously discussed. So here's a brief outline of the discussion. Next, please. So it's been 4 years since the pandemic started. So it was a nightmare for all of us. Here's a short timeline of key events from 2019 to 2023 related to tonight's discussion. And a lot happened during these times. Fast forward to today, I hope everyone is safe, healthy, and vaccinated. So data from Johns Hopkins showed that there are over 4 million recorded COVID cases and around 66,000 lives lost in the Philippines alone since the pandemic started in 2019. So only 71% have been vaccinated as of March 2023. Our government has the duty to protect and promote our right to health, as can be seen in several constitutional provisions. But to fully realize our right to health, we need access to medicines, vaccines, and protective gears, among others, as mentioned by the keynote speakers a while ago. So I know all of us has our own stories about how we survived the pandemic, but the key to that is that we now use face masks every day, and we're all vaccinated. So for our pharmaceutical products, which we are already existing and available, it's relatively easier as it's only a matter of accessibility. But what about those products which are not yet existing? So remember from the timeline, it took almost a year from when the pandemic started in December 2019 up to when the US FDA issued the emergency use authorizations for the first few vaccines available. So it cost us millions, and I think it put us in debt to buy those medicines in order to protect ourselves from the virus. So, as mentioned by our professor a while ago, these medicines are covered by intellectual property rights, specifically patents. So first we review what's a patent. A patent is a type of intellectual property right given to patentable inventions, and patentable inventions are any technical solution of a problem in any field of human activity which is new, involve an inventive step, and is industrially applicable. So if you have a patent, you can prevent someone from making, using, selling, offering for sale, or importing, or as we call it, a mousey, from our professor, the patented product or any product obtained directly or indirectly from a patented process. So looking back at how we dealt with the pandemic, is there a way by which we can improve public health and protect the lives of people while still respecting intellectual property? So data from the World Intellectual Property Office showed that China and US, two big countries, filed majority of the COVID-19 vaccine patent application. So this is only data from January 2020 to September 2022. In our timeline earlier, it showed that South Africa and India in October 2020, they were backed by other developing countries in applying for a patent waiver to the World Trade Organization. So what's a patent waiver anyway? So a patent waiver will allow others to create or manufacture the vaccines and other medicines or products without the fear of being sued by the pharmaceutical companies which owns the patent. So of course, it's a waiver of a right, and naturally it was met by a number of support and also opposition. So there are several pros and cons discussed by experts. So now we discuss the pros. The waiver was seen, or hopefully, it will boost the production of vaccines and other life-saving products. Another pro is that although there is compulsory licensing, as mentioned by Angelica a while ago, it's a complex and time-consuming process. And remember, back then, we were still in the middle of a deadly pandemic where time is of the essence. So now we look at the cons. Experts say that the waiver might increase vaccine hesitancy, and critics say that if people are already hesitant to be injected with vaccines manufactured by big companies, what more those vaccines manufactured by third-party suppliers after the waiver is granted. Also, they fear that granting of patent waivers will take away the incentive of researchers to come up with new solutions to our problems if they will not be able to profit from it. Imagine the time, the money, and the resources spent before a medicine or a vaccine is produced, and then everyone can just take it for free. So there's one striking point in the midst of the debate on giving a patent waiver. The question is if a waiver is granted, how sure are we that developing countries like the Philippines will have the resources to make their own vaccines? So in April 2020, so I think that's the first 4 months of the pandemic, former President Duterte offered a quote-unquote bounty to any Filipino who can develop a vaccine against COVID. But has the Philippines developed a vaccine? So let's go back to the waiver. 2 years after the application, or in June 2022, the World Trade Organization allowed the waiver of some rights in the TRIPS agreement, which is the most comprehensive multilateral agreement on intellectual property. So the decision is not called a patent waiver verbatim, but it's called the ministerial decision on the TRIPS agreement, but it's related to the application for a patent waiver. So one of the salient points of that decision is that developing countries can limit the rights provided for under Article 28 of the TRIPS agreement. So Article 28 states the exclusive rights of a patentee. So they can now authorize the use of a patented product for the production and supply of COVID-19 vaccines without the consent of the right holder to the extent necessary to address the pandemic. Of course, this is subject to limitations and also only applicable for 5 years from date of adoption or starting June 2022. Again, we go back to the question I posed earlier. Even stifling intellectual property rights, we must encourage local research by giving scientists enough support. Instead of a quote-unquote bounty, maybe we can allocate government resources for research and development. The government, among others, should also prioritize the public health sector by paying our healthcare workers a living wage. So even with a waiver on intellectual property, the country unfortunately still has not produced any vaccine. The question of whether we have achieved vaccine sufficiency and herd immunity, especially in light of the recent increase yet again of COVID-19 cases, remain to be answered. More so, the question of how we can survive another pandemic might be a question we do not want to hear an answer to, at least not yet. So that's all for my presentation. Thank you, and I'll give the floor back to our host.
Thank you so much, Yvette, and also to Angelica for emphasizing our ever pressing need for universal access to essential medicines. Thanks as well, Yvette, for refreshing our knowledge on patent law. We truly will never forget Mousy and Mam's
Yes.
other memory hacks from this class.
All right. And to our audience members, if you have any questions or reactions for both Angelica and Yvette or for any of our presenters today, please send them in through the Q&A button.
Yes, just click that Q&A button at the bottom of your screen and send in your question along with your nickname if you want to be recognized during our Q&A portion later on.
Yes, and remember, guys, this is a safe space for your questions. Feel free to send your thoughts, your inquiries as we go along. But if you'd like to stay anonymous, just tell us. That's fine as well, especially if you've got any violent reactions.
Well, speaking of violent reactions, we've got quite the contentious issue coming up in our next presentation.
How contentious are we talking about here, Therese?
Well, Charlie, what is your stand on artificial intelligence taking your job as a host for this afternoon?
Well, if AI will take my host, that means I can go home now. That'd be nice.
No, no, you can't,
Okay.
because actually we'll be presenting next. Ladies and gentlemen, please welcome Miss Myrene Repizo, who will be joining Charlie and I as we bring you our next presentation on confronting the Black Mirror, a dystopian view of AI and IP.
Yes. Hi, Myrene. Thank you for joining us as we explore human rights issues brought about by rapidly advancing technology and how this affects our intellectual property. And Myrene will be discussing security and privacy issues in her presentation, Law Enforcement. Big Brother is watching.
Thanks, Charlie. Thanks, Therese. So, good afternoon, everyone. For this presentation, we will be presenting studies on various intersections of AI and intellectual property. For the first study, we will discuss law enforcement. We will go through some existing examples, identify the underlying conflict between AI and law enforcement, and finally suggest a framework or an approach on how to address said conflict. To guide us in this presentation, we first answer the question, what is AI? According to Britannica, it is the ability of a robot or computer to perform tasks and intellectual processes characteristic of humans, such as reasoning, generalization, and learning. In order to reach this ability, there are numerous algorithms and lines of programming involved, and so AI as a computer program is generally protected under copyright. Going into AI and law enforcement, the topic is not a new one. In fact, it is already found in numerous works. As examples, we have the AI Skynet seeking to eradicate humanity and Terminator, crime-solving AI in Persons of Interest, the AI systems in Psychopaths and Nosedive that decides how a person lives or dies based on their daily actions or their potential to be a criminal. But how close are we to the pictures painted by these works? To answer that, the answer to that is we're getting there, but we're not doomed. Here we have some of the often cited use cases when it comes to AI and law enforcement. First, we have facial recognition technology, which is useful for identifying unknown suspects captured in crime scenes and for locating fugitives on the run. Similar to Nosedive, we have China's social credit system. Based on the 2022 draft law, data will be collected among different government agencies to create a social trustworthiness profile of companies and individuals. Socially untrustworthy individuals are not allowed to limit and even enroll in prestigious schools. Lastly, we have predictive policing. Using various data and analytics, police can prevent and respond effectively to future crime, essentially putting officers at the right place at the right time. Underneath these technologies, there is an underlying conflict. And that is, on one side, we have our constitution decreeing that the prime duty of our government is to protect the people. And yet, on the other side, we have these rights in the Universal Declaration of Human Rights. For this presentation, we're limiting it to three: right against arbitrary detention, right to be considered innocent until proven guilty, and the right to privacy. The first thing that comes to mind when we think of the duty of the government to protect the people is police power. We have numerous jurisprudence explaining that police power as the government limiting certain liberties to promote public welfare. As it is very broad, we can easily imagine an agency issuing a memorandum stating that in order to promote public welfare, we will start to implement this so and so AI technology. However, as can be seen in jurisprudence, despite how broad police power is, it still has its limitations. Rights must still be recognized and there must be a sound basis to exercise. As for the rights affected, the first right that we will discuss is the right against arbitrary detention. In our local laws, it is found in our Bill of Rights and in the revised penal code. This right is at risk because, as typical of any AI program, there will always be false positives. Or in this instance, a person is detained because the AI program mistakenly identified them as someone who should be detained. However, this risk can be mitigated because our laws require that there must be a legal ground before detention is possible. We can remove some small factors, such as not picking up the trash from the algorithm, which is currently a problem in the local implementation of China's social credit system. The next right, which is closely related to the previous right discussed, is the right to be considered innocent until proven guilty. This is also found in our Bill of Rights and in the concept of quantum of proof, that there must be sufficient evidence before a person can be adjudged as guilty. This is at risk similarly because of one, the risk of false positives, as earlier explained, and two, AI programs will eventually have the capability to make decisions, in this case, to decide whether a person is guilty or not. However, this is also limited. This risk is also limited by the appeals mechanism and rules on judgments. Laws and rules require that judgments must be written based on facts and law. Now, if there is a question on the judgment, we can always appeal and insist why a judgment was wrongly made. Lastly, we have the right to privacy. It is also found in our Bill of Rights and our Data Privacy Act. This right is at risk because we may end up collecting too much data and overstep into others' daily private lives. In making accurate AI programs, it is necessary for the program to consume large amounts of data from various resources. There will always be the question, how much data is too much? Just like with the other rights, it is also limited. The risk is also limited. The limitation is in the strict scrutiny test that requires compelling interest to avoid abuses. And there's also the rules of evidence such that any data improperly collected will not be considered as evidence. Next slide, please. Given the conflict and the affected rights, how do we balance this? We look first at the copyright law. When we look at the intellectual property code, see the benefits of copyrighted work, the economic rights or how the author can earn from his work, moral rights with the right to be associated being one of such rights, and related rights with some rights under this category related to performers. However, despite all these benefits, there is no list of exclusions on what works should not be copyrighted. Considering that, there are two options on the framework. First option is to add an exclusionary clause to copyrightable works, similar to what we see on the law on patents and the law of trademarks. However, the challenge is that this is in conflict with Section 172.2 of the IP Code. Works are protected at the moment of their creation, regardless of their content. This option might require legislative action. The second option avoids that and goes to the implementation. Patterned after the recommendation of the US Department of Defense, we follow the ethical principle that AI applications should be one, responsible, or that personnel shall be responsible for the AI program, two, equitable, that unintended biases in the AI are minimized, three, traceable, that the processes are auditable, four, reliable, or that the program is secure, and lastly, governable, or that there is an ability to detect and avoid unintended consequences. The other half of this second option is to have an assessment of how involved an AI program should be. Should the process be entirely automated or must it be validated by qualified personnel? For this, we defer to the expertise of our qualified personnel in government. In the end, despite the numerous works and existing AI technologies on law enforcement, we won't see any Terminator walking through the streets anytime soon. We have numerous laws and mechanisms in place. As long as you keep in mind ethical principles and responsible AI programming, the future will not be as dark as in the movies. And that's the end of my presentation. For the next presenter, let us welcome back our lovely Ms. Denise Bohol.
Thank you, Myrene, and hello again, everyone. For my study, The Copyright Conundrum, will be spotlighting a special issue in copyright law that we must now confront thanks to the disruptive force of extraordinary innovations in AI. Next slide, please. This may look like any ordinary painting, but in fact, this is the portrait of Edmond de Bellamy, the first AI-generated artwork to be auctioned by a major auction house alongside man-made prints by renowned artists like Andy Warhol and Banksy. It sold for nearly $500,000, priced higher than all of its other man-made counterparts in that auction, save for the Warhol prints. What's interesting is this portrait was generated by an AI program that was fed 15,000 portraits painted by humans between the 14th and the 20th century, without which it could never have produced this image. So I present you with our copyright conundrum. In an age where AI machines can generate work that are becoming more and more indistinguishable from works created by humans and more independent from human intervention, who is the author? Who can we say actually created the work? Is it the AI developer who may not have any artistic skill, but is the one who programmed the set of algorithms instructing the machine how to think, how to behave? Is it the human artist whose work, produced through their own artistic creativity and skill, was used to train the AI, or could it be the AI itself? In copyright law, ownership of the copyright is determined in the first instance, generally by this question: who is the author? Now, under international law, the Berne Convention, as incorporated into the TRIPS agreement, leaves it to the individual states to define authorship. Article 2 lists the different artistic and literary works protected by copyright, but the treaty itself is silent on who would qualify as an author. Given this, there have been calls to recognize AI machines as authors under domestic copyright law. This image you see here was generated by an AI program developed by Dr. Stephen Thaler called the Creativity Machine. It runs on AI systems patterned after the human brain, known as a neural network, enabling the AI to demonstrate creative skills and originality that Dr. Thaler himself does not possess. So Dr. Thaler has embarked on a worldwide campaign to get different countries to recognize his AI machine as the author in his applications for copyright registration. In our jurisdiction, at least, our own IP code clearly defines an author as the natural person who has created the work. This poses a conundrum. On one hand, machines, while arguably the rightful creator, do not qualify as natural persons and hence cannot be considered authors under the law. On the other hand, the nature of the technology we have today removes the participation of any natural person from the creative process, so much so that they cannot be said to have actually created the work. Thus, there is a gap. Would these works generated by AI receive any copyright protection at all? And if so, to whom shall protection be attributed? To solve this conundrum, we might find the solution we need in viewing intellectual property through a human rights lens. The rationale for this is echoed in Professor Ricketson's 1987 address to the WIPO, wherein he lamented that a legal evolution moving away from human-centered notion of authorship might lead to a soulless copyright regime where the protection of the fruits of human authorship is devalued or relegated to the sidelines. This may in fact be happening now in an age where AI can use your work, study it, exploit it, even copy elements of it, while being heralded as the author of the work thus generated. But through a human rights lens, human rights as being fundamental rights take precedence above all, which cannot simply be set aside in the name of innovation and advancement. My study thus utilizes Peter Yu's framework for analyzing the interplay between human rights and intellectual property rights. Yu propounds that there are specific and limited attributes of intellectual property rights which do qualify as human rights in that they have a human rights basis. The rest, lacking any such basis, must be subordinated to fundamental human rights obligations. So if machine authorship is detrimental to human rights, it is defeated by those intellectual property rights that qualify as human rights by their very fundamental nature. And under the Universal Declaration of Human Rights, everyone has the right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. This is similarly adapted under the International Covenant on Economic, Social, and Cultural Rights. These provisions serve as a human rights basis for the intellectual property rights, referring to the moral rights of the authors, as well as their exclusive rights, economic rights over works created by them. Given these bases and framework under the human rights lens, my study puts forth three major points in crafting solutions to our conundrum moving forward. First, moral and material interests of the author are human rights. Though society may evolve and our technology advances, may we never lose sight of the fundamental nature of human rights, which includes protecting the moral and material interests of the human author. To this extent, the concept of authorship under copyright law must be reserved to natural persons to preserve the law's so-called soul in the protection of the fruits of human authorship. Second, there is a need for sui generis protection to fill in the gap for AI-generated work. The gap we have confronted today demands that legal rules be carved out which are specifically adapted to AI and which provide subordinate protection appropriate to AI-generated work without unduly compromising fundamental human rights. And lastly, overall, a balancing of interests must be maintained. The interplay between intellectual property and human rights emphasizes fairness, which is only achieved through a proportional balancing of interests, as my classmates have emphasized so far. After all, promotion of one's economic and commercial interests is immortalized in our intellectual property laws, not to the detriment, but for the furtherance of human dignity. So that's it for me. I shall now cede the floor to my dear classmate, Mr. Charlie Damaya, for his presentation.
Right, thank you very much, Therese. Now, let's talk a little bit more about machines tearing things away from humanity. And we'll be talking about labor rights in the AI gold rush that is going on right now. From what we have heard thus far, we get the picture of artificial intelligence as being either the goose that will lay the golden egg or the straw that will break the camel's back. In a pretty literal sense, the future of civilization can be well defined by how well we use or misuse this technology. But there is a vision of an AI dominated dystopian future that we rarely think about. Now, think of it this way. Civilization is flourishing all around us. Things are working almost as well as they should. Except that most likely, a vast majority of us will be living under the charity of the few powerful entities who have unlocked AI's full potential, the ability to think like a human being. And when that happens, even our jobs will disappear. Now, the right to gainful employment, against unemployment, the right to just and favorable conditions at work, which is a universal human right, is at risk. After all, who would pay us to work if there's an alternative, a maintenance free entity that requires neither pay, nor benefits, nor leaves? Now, this is already happening all around us. You see, the AI revolution is very different from the Industrial Revolution. From steam to electricity to the internet, the previous revolutions all found a way to make production better, faster, more efficient, but not necessarily smarter, since that requires the decision making prowess of a human. The ability to be creative and to draw experience and other intangible assets, that was our last frontier, and it's slowly being taken away from us. And I'm not just talking about creatives losing their jobs and their likenesses and their abilities being encoded into software, like that famous Black Mirror episode with Salma Hayek in it. If you haven't watched it yet, it's really creepy. In the business process outsourcing sector, for example, various jobs that require snap decision making, such as content moderation, product selection, they're slowly being taken over by AI. Now, the image we see on the screen is a graph that was compiled by Accenture, which is a leading global BPO company. And we can see just how much impact on employment AI has on the field of language modeling alone. So we're talking about a very, very specific type of AI here. We're not yet talking about other breakthroughs, such as the advent of AGI, or artificial general intelligence, which some commentators will say that is possible within the next 5 years. But it's not like AI learned all their skills out of experience and a broader understanding of the world. In fact, AI can learn only through a very specific training process, a process where completed decisions are fed into its algorithms. And then these outputs are reverse engineered. From here, AI will attempt to reconstruct the same decisions when faced with a different set of variables. Then again, the training data that's used by AI is being produced by humans, specifically the employees of the organizations that seek to replace them. These are decisions that were made through the collective experience of those involved, and thus this isn't something that employers can program on their own. So they monitor and they scrape the data as it is produced, and this is currently a rampant practice that employees are not protected against. In essence, the more they work, the more we work, the more we generate data that can be fed into our future AI overlords. But the current milieu of labor market tells us that these bits of data have economic value on their own, and they can define the conduct and the results of a business. Thus, it stands to reason that they should be recognized as intellectual property and should be afforded a level of protection. Now, the question is, what type of protection? These bits of data cannot fall under patent or trademark. They already have very specific definition under the global legal regime. They may be considered for copyright, but it's also a very strict global implementation, and there's not much room for adjustment. Instead, we can call upon the concept of trade secrets, and this is something that has also been discussed earlier by one of our presenters. This is one of the less talked about types of intellectual property, and trade secrets are unique in several ways. First, they are the only type of IP that is hinged upon the concept of secrecy instead of registration. As long as the world at large does not know about the process, it can be accorded trade secret protection. Second, it has been recognized as a prime mover in businesses, with many corporations admitting that its economic importance in their day-to-day operations is of, well, some primacy. Some even rank them as more important than patent and trademark. And third, this is a pretty flexible concept that is admitting of modern interpretation. So as an example, internationally, the concept of trade secrets is only loosely bound by Article 39 of the TRIPS Agreement. And as the entire article has been reproduced on screen, as you can see, the overarching concept is that of the protection of undisclosed information. At the European level, this has been refined to mean any non-patented practical information that is not generally known or is easily accessible, with more formal trade secret legislation, such as that in the Swedish Trade Secret Act, in the second bullet of the presentation on screen. It is defined in practically the same way, with the added note that its disclosure will be harmful to the proprietor from a competition point of view. Now, this places the disclosure of trade secrets within the bounds of the concept of unfair competition, a very prominent concept in commercial law. And this is recognized in many other jurisdictions, such as Poland, Greece, and the Czech Republic, mostly in the European region. The United States, of course, very powerful in global commerce, refuses to exactly define the concept of trade secrets. It gives a very loose definition and it characterizes it as a confidential, commercially valuable information. Now, as we can see, individual jurisdictions are free to have their own legislation to cast a smaller net around what a trade secret should be. And it is this flexibility that makes trade secrets very easy to use for business. Should, for example, a trade secret holder want to, they can be transferred or licensed through contracts without much legal overhead. Now, trade secrets can be utilized as a means to protect employees from the rampant scraping of their outputs for artificial intelligence training purposes. So long as such processes measure up to the standards of secrecy, meaning it's not generally known, and so long as these processes provide any modicum of economic value to the business, then these processes can be and should be treated as trade secrets. From here, the default treatment of such data should be one of protection and not free access. Usually, such free access is given through the employer-employee relationship, and that leads to exploiting of the employees. Should the employers wish to use such data for AI training, the terms should be set forth in an explicit agreement between the employers and the employees. After all, our goal here is not to kill artificial intelligence. It's still a tool. It still has its uses, which will benefit us in the long run. The goal here is to ensure that employees are not blindsided. Their basic right to gainful employment to be unjustly taken just because their company decided that, hey, I've gotten enough data out of you. Now yield your seat to your new non-human replacement. When we have employees that have trade secret rights over their decision-making processes, they also have rights to how such data should be treated. And this way, we'll be able to take back a measure of control over a future of dystopian labor rights and opportunities. Thank you very much. And back to you, Therese.
All right, so that now concludes our group's presentation on the importance of viewing artificial intelligence through a human rights framework. As always, we are really glad to hear your thoughts as you share them with us through Zoom's chat features. One of the interesting comments that we got during our presentation is from Angela Santiago. So Angela says, one of the fundamental concerns about AI, some models are black boxes. We do not know how these AIs act the way they do. Thus, there is clamor for transparency and explainability in AI models. However, companies can opt not to open up their models, even though public interest necessitates such, hiding behind trade secrets. So, that is also a human rights concern. Very well put. Thank you so much, Mr. Santiago, for weighing in on that.
Mhm.
So,
And
yeah.
yes, for those of you who might have just joined us, you will also be having some Q&A portion later on. So if you have any burning questions like we just showed, please type them into either Zoom's chat feature or through the Q&A button below.
That's right. For now, we move on and jump into the field of trademarks is another type of intellectual property. And Charlie, what a ubiquitous IP this is.
Yes, that's right. So this is something that we encounter every day. And in order to enlighten us more on the concept of trademarks, a very specific topic on trademarks, ladies and gentlemen, we move on to our last but definitely not the least presenter, Mr. Jean Raniel Sanchez, on his study entitled Trademark Protection of Domain Names vis-a-vis similarly named but non-trademark domains. Take it away, Jen.
Hello, I'm Jen Sanchez, and I will be speaking on trademarks versus non-trademark domain names and the conflicts of rights that may arise between them. Let us begin by identifying key concepts. A trademark is a form of intellectual property defined as a visual mark that identifies the business providing goods and services. Under the Intellectual Property Code of the Philippines, trademark protection, which is primarily the exclusionary right to use the mark, is granted upon registration with the IPOPHIL. Recently, as in December 2021, the Supreme Court has ruled in Colin Electronics versus Taiwan Colin that a registrant of a trademark may also register a domain name that uses the registered mark as its dominant feature for the same goods and services covered by the first registration. The court acknowledged that domain names perform similar functions as trademarks on the internet, advertising and identifying a business's goods and services. But what is a domain name? A domain name substitutes an IP address. It is a human-friendly way to access content over the internet and is part of the Uniform Resource Locator. These are fundamental to building a business's website as the registrant of a domain name has leeway to choose their preferred domain name subject to availability. A domain name is part of the domain name system, usually described as the quote-unquote phone book of the internet by the way it directs human users to the websites they seek. It is a hierarchic system that, when read together, provides the user with the entire domain name. Domain names are registered with the domain name register, and the registration grants exclusive use of the domain name to the registrant. We can therefore identify a possible conflict of rights. The exclusionary right of a trademark registrant and the right of a domain name registrant to the peaceful enjoyment of the domain name. At this juncture, though, let us mention abusive registrations of domain names. These are bad faith registrations of domains done to tarnish an entity's reputation or to hold it for ransom for the intended registrant. For example, these show a these show our registrants intend to harm and would therefore inarguably be grounds for some sort of legal action. However, we are more concerned with good faith registrants who do intend to use a confusingly similar mark for legitimate purposes. To visualize this, let us consider a scenario. A business has registered their mark with the IPOPIL. A third person, a regular human, has registered a domain name that may be confused with the registered mark. The business, now attempting to register a domain name with their mark as the dominant aspect in line with the Colleen case, finds about the previously registered domain name. Now, the business uses the strength of its prior registration to demand that the domain name registrant cease the use of their website under pain of legal action. Given our hypothetical, then, we can identify some characteristics in this conflict, whether intellectual property rights trump peaceful possession of a domain name, and whether the good faith defense in the IP Code of the Philippines can be applied via a trademark and a domain name. As the first, it may be argued that trademark rights should be preferred due to their purpose. This reason being that the very purpose of a trademark is to prevent the unauthorized use of a mark. This should be applied even if the trademark owner had not trademarked a domain name for themselves. Domain names, after all, may or may not have a relation between the name and the content of the website. Trademarks are more narrowly used for business purposes, and the specificity in purpose is why they should be prioritized. We posit, however, that intellectual property protection should not be prioritized over the peaceful enjoyment in possessing a domain name. We acknowledge that under Article 27 of the UDHR, a person is entitled to the right of protection for their material and moral interests in scientific, literary, or artistic creations, intellectual property rights, in short. However, under Article 17 of the same declaration, a person intrinsically has the right to own property and be protected from its arbitrary deprivation. Between these two rights, we suggest that the general property rights in Article 17 should be preferred over a trademark protection. It is conceded, definitely, that intellectual property is also property. Therefore, the holders of IP rights also have the same rights under Article 17. However, there is an extra dimension to intellectual property rights. It is their exclusive nature, which is the crux of the conflict. We argue that this should be mitigated, in fact, by applying the right against arbitrary deprivation of property in Article 17, uh, section paragraph 2 of the UDHR. We may apply this because of the factual circumstances. Domain names, as we've seen earlier, may be easily confused since they are mere strings of text and that small changes in the spelling or in the top level domain being used may lead users to wildly different sites. This therefore creates an uncertainty into the intent of a domain name registrant to use the same or a similarly appearing domain name as that of a mark and should be a basis for to mitigate the exclusionary rights of trademarks, lest the enforcement of these IP rights cross into arbitrary deprivation of property already. So we're stemming from this. Should the prior good faith provision of the IP code apply? We posit that yes, it should apply because the protection, yeah, because the protect because the protection due to registration with the IP field should not be so casually extended into the virtual space absent another registration of the domain name. We argue this because to hold otherwise would contradict once again Article 72 of the UDHR. There's a fundamental difference between a trademark and the domain name, and it must be recognized. A trademark is intellectual property. While its protection is certainly included in the UDHR, it's also included in Paris Convention, if I recall, and TRIPS. The incidences of the protection, so how the protection is made, remain statutory creations, such that the details of protection due to a registered mark would be territorial in nature, which depends on the country. Domain names, however, these are more international in scope. A registrant may or may not be aware of what names or terms have been afforded trademark protections in which jurisdiction, and we cannot actually presume that they know. Adding to this, domain and trademark registrations are two wholly separate processes. Registration in one could not serve as a notice into the other. So we therefore argue that domain names should likewise be first registered as trademarks before the good faith clause would not apply with respect to trademark protection actions, because if I recall, the WIPO also has a list of the trademarks of other countries, and that could serve as some sort of notice as well. So to conclude my little rambling, the advent of the digital age has caused consumers to move from the internet and with them the businesses. All else being equal, the first way a business can differentiate themselves online is through the URL that would direct the consumer to their website. Thus, domain names have taken the same role as trademarks and in fact can be registered as marks, as we've seen. However, the internet, we must recall, is not solely a business venue. Websites has been and always will be created by regular people for their own reasons. Their rights as domain name owners, these are property rights, must always be considered when extending trademark protections into the internet, that no one is unfairly prevented from using and enjoying their own property. And finally, we would like to end this recommendation that further study regarding the extent to which trademark domain names may be protected, considering one, the territoriality of intellectual property protection, via two, the global nature of domain name registrations, and this should be considered. Thank you.
All right, thank you so much, Jen. And that officially concludes our set of presentations for today. Ladies and gentlemen, a round of applause, please, for Jen and the rest of our presenters who took us on a fascinating journey through the field of intellectual property and human rights.
But wait, there's more. For our next part, we are honored to have here with us today distinguished guests of honor, a panel of experts on the field of intellectual property and humanitarian law, to share with us their thoughts and reactions on the presentations that we have seen this afternoon. Our first special guest is Dr. Frederick Romero. Dr. Romero is the director in charge of the IP Academy, which serves as the National Center for Knowledge, Learning, and Development of Intellectual Property. He is also a director of the Bureau of Copyright and Related Patents, focusing on strengthening the Philippines' economic backbone on the promotion of IP rights.
Yes, and we're also honored to have with us Attorney Michael De Castro. Attorney De Castro is a humanitarian lawyer and a dedicated advocate of human rights. He is known as the founder of Lehis, a network of lawyers at the front lines of our country's fight for the preservation and furtherance of democracy through education and legal practice. He has represented clients before all levels of the Philippine justice system, deploying arguments featuring freedom of speech and its cognate rights, the right against unreasonable searches and seizures, and the right to a balanced and healthful ecology, among others. He teaches constitutional law too and obligations and contracts in the UP College of Law, as well as practice court, legal forums, and clinical legal education in the DLSU Tanyada Diokno School of Law. Ladies and gentlemen, please welcome our distinguished panelists as they share with us their feedback on the presentations. Let's start with Dr. Romero. Dr. Romero, any insight you'd like to share either on a particular presentation you've seen here today or perhaps the presentations in general?
Yeah, thank you, Therese and Charlemagne,
Charlie. Sir.
Carl, for the introduction. Before siguro I share my thoughts. Congratulations muna to the authors, to the students for your work. I'm sure you have a very short time in terms of preparing for this research work. But they were all well prepared, and I see the passion in terms of your you want to balance the human rights and intellectual property rights. So definitely you're the first batch of this class, and for sure you've already felt that there's an intersection talaga between human rights and IP rights, because evidently, as you mentioned a while ago, it raises a lot of complex issues. And um, these two areas of law, they're always into tension with each other. One, of course, is yung access to knowledge. I'm not sure if it was discussed a while ago, but one basic right, human right as well, is the right to education, and that's something that you have to look at as well. There are a lot of papers that touch base on right to health or right to public health, and some papers touch base on cultural and indigenous rights. So definitely, in order to address these tensions, uh, there's a lot of things to do, and the intellectual property and human rights system, not just locally but internationally, is very complex. It's very challenging. So we need cooperations from different stakeholders, government, private institution, academic institution, international organizations, so that we can harmonize human rights and intellectual property interests. And as mentioned by a lot of you a while ago, we need to develop frameworks. We need to develop new laws, update our laws, update our guidelines, so that still we can push for innovation. Because why innovation is important? The reason you're enjoying your life right now is because of innovation. A creator, an inventor, an artist created inventions, songs, movies, books, businesses, so that you can enjoy a good life. So we have to push for innovation, letting them to encouraging them to create more of these properties. But on the other hand, you also have to promote equitable access to knowledge and cultural resources. So it's good that right now you're very, very aware of what you're doing in terms of intellectual property and human rights. Some of the topics that siguro I have some comments. One is the protecting living knowledge, challenges to protecting genetic resources and associated traditional knowledge, GRATK, in the Philippine patent law. Commendable that you mentioned there as an area of of discussion is what exactly constitutes TK or traditional knowledge. That is a great point, since sometimes indigenous tribe members, they have their own intellectual properties. Some of them, they may have their own inventions. Some of them may have their own businesses, products, services. So it is important to really define what constitutes traditional knowledge. Okay. And you also suggested on creating a database. I assume that the database that you're referring to is a database of the traditional knowledge. Can someone is the, can the author um, answer me ba, or you can chat
Uh,
na lang. Tama ba?
yes, sir. Yes,
Yes.
sir. I was referring to the IKSP registry and efforts to make it.
Yes. So you've clarified that the database is for the list of traditional knowledge. Let's look at the Philippines muna. Right now, we're not sure. I'm not sure. Personally, I'm not sure if we have a list, a registry of traditional knowledge in the Philippines. If we do have, I'm not sure if it's updated. It's important. It's a good point that we create this or do we update this, because as you mentioned a while ago, person or a company, if it creates an IP, an invention, which in the first place they don't know if it's a part of a traditional knowledge. So it's good to have a database to at least double check, determine if they're already violating the rights of indigenous tribes. But on the other hand, you have to also look at it. If there's a database, you need information, and not all, of course, but probably some of the tribes, they don't want uh, to give information about their traditional knowledge. So ano rin yan, you have to look at the other side then. There's a database, yes, but even the tribe, some of them, I'm not saying all, may not be too open in providing information about their traditions. So uh, that's going to be a challenge, definitely. Okay, so but again, that's a good point there. Another topic, another paper is the intersection of patent rights and human rights, an analysis of domestic patent laws, international agreements, on the context of balancing pharmaceutical patents and access to essential medicine. It was discussed a while ago, yung trade secrets mandatory licensing, and I respect and I see the value in terms of you know eh, di ba, to circumvent yung patent law, companies will just do trade secrets, especially if the invention or the product is really beneficial to the society. And I understand yung point that you have to at least amend the law or revise a few provisions so that there can be a mandatory licensing for trade secret. That's good, actually, in a way, because at the end of the day, uh, the state should create actions that will benefit the people. But look at it on the other side. If I'm the inventor or the creator of the trade secret, and I know, okay, example, I created a drug, and it's beneficial to the society, and I know that there's a provision. Example lang, the provision for trade secret mandatory licensing. Diba? I know that the government or the law will say na, trade secret yan, make it public, automatic, voluntary licensing. If I'm the inventor of that trade secret, then from now until forever, if if that will happen, then I will no longer create drugs. I will no longer create products. Diba? Kasi there's that idea. And remember, you may say na uh, creating drugs and pharmaceutical products, it's not cheap. Hindi siya mura. It takes millions of pesos or billions of pesos. So yeah, I get the idea that it's good to have mandatory licensing on trade secrets, but you have to understand also the other side, the creators. They're not there 'di ba? Um, kumbaga to hindi naman sila public, hindi naman sila public servants eh. These are private individuals, inventors. They have their own personal um, reasons then in creating these products and services. So if that's the case, may mandatory licensing and trade secret, then di na lang ako magkagawa ng invention o ng trade secrets. Na sana, I could have created a trade secret and sell it to the public, of course, based on my price. But because of that law or siguro provision that you want to push, ay hindi na lang. And the other, diba, inventors and creators will also do that. And that's going to be a challenge then. So, yun nga, sometimes we have to balance then eh. I'm not saying the proposal is wrong. I'm not also saying that the proposal is correct. It's just, it's right now, it's really, really challenging. The other topic kasi medyo marami, may isang group tapos putol-putol siya on patent waiver. That's actually good. But you may also look at patent pledges. Take note of the term patent pledges because aside rather than waiving the patent, maybe it's better to push for patent pledges, which is a publicly announced intervention by patent owning entities or the pledgers to license active patents to make it restricted or unrestricted or pwede rin siyang a certain condition. Example, uh, for 5 years lang. Example, for COVID, for the first 5 years, we will, you can use it. But after that, I own it already. Baga, babalik sa akin yung rights ko for that patent. So, another course of action then in terms of, providing benefits to general public. Okay? Next is, sorry, dire-diretsuhin ko na Miss Therese and Char. Confronting the Black Mirror, a dystopian view of AI and IP. I'm a fan of Black Mirror nung hindi pa siya Netflix, pero ngayon medyo hindi ko na siya gusto. We should look at clarifying the term exclusionary clause to copyright works. Okay? I think this is about yung law enforcement. Law enforcement use AI using law enforcement. And you talk about copyright. Maybe you should look into the law enforcement rather than the copyright. Okay? Kasi it's like saying ganito eh. I created a song which is copyrightable, di ba? And then the song was used to defame another person. Example lang, to defame. Should I be liable? Should I be, kumbaga, tawag dito, sued because I created the song? Diba? You have to look at the other laws, diba? Governing law enforcement. Probably yung libel law or the others. Yun lang naman yung ano ko doon. Parang you're saying kasi na there's AI in terms of tawag dito yung AI policing and so on and so forth. Okay? It's about you have to look at yung I'm not a lawyer of course, pero what I'm saying is you have to look at the enforcement law rather than the copyright law. Okay? But of course it defeats the purpose of human rights and copyright kung inalis mo na yung copyright. Okay? The second topic, the current copyright law, I think it's about the ano nga ba yun? Generative AIs. I think it was your paper, Mysteries. So you are correct. The current copyright law provides that authors should be natural person, and hoping that in the future, okay, the law will not be amended in such a way na it's a juridical entity or a natural person. Okay, but however, probably we have to also protect those individuals creating the system. Okay, provide protection to individuals who are vital in creating generative AIs. Yes, personally, definitely yung copyright should belong to a natural person, but hoping that in the future there should be a law or regulation in terms of giving protection then dun sa individuals that created, di ba, the the system that generates AI. But don't worry, AI as a topic, as an area, is really a delicate topic, not just in the Philippines, but globally. Very few countries have certain rules in terms of generative AI or AI. UK lang ata or US or the others. So we're of course as part of the government, we're doing our best to really push for, you know, looking at how we will handle this type of areas, especially in the digital world. Yung last naman, kay Charles, siguro the question now is, di ba, it's about the labor, diba? Labor and AI. But you ask yourself, can we stop companies from using AI? Diba? Can we stop them from laying off employees due to innovation and redundancies? Always remember that at the end of the day, for businesses, their number one goal is profit maximization. So it's hard that, you know, some people will be let go. Pinakita kanina yung graph, okay, in terms of yung chart, in terms of ilang percent na yung nakukuha ng mga AI systems. So but those are the realities kasi. Can we stop them from using AI? I don't think so. Can we stop them from being more effective, more efficient? And with that, di ba, limited manpower na. It's almost the same as robots, di ba? Robots. So hopefully in the future we can look at those things more in depth. Okay, and last the last topic, trademark protection for domain names, the vis-a-vis similar name but non-trademark domains by Mr. Jen Sanchez. Siguro my question lang is, do you have other examples of confusing similarity between domain names aside from the one given? Because what you use is .co, I think for Colombia, and .com. So are there other confusing similarity between domain names? So baka we're only looking at that example. That's one thing. Second is, we should also look at how these parts be considered as the dominant feature of the domain names, especially if it's just a .co or .com. Okay, so kasi you mentioned in one of your slides yung dominant feature in terms of, diba, determining infringement. So that's something to think about. And in trademark kasi, there's disclaiming pa rin. Merong disclaimer pa din na ginagamit in terms of what the owner would like to protect and what is not part of the protection. So it can be used so that we can avoid further issues. So for now, those are my comments lang, Teres. Apologies for the extended review, but thank you so much for all the papers, and I hope in the future you really practice intellectual property. That's how beautiful intellectual property, how strong and powerful intellectual property law is. Thank you so much.
And
All
thank you
right.
very much for your incisive comments, Dr. Romero. Indeed, there are so much opportunities for these fields and various conflicts and viewpoints, and we can only hope our presentations may inspire more discourse on the topic.
Truly, Dr. Romero will be sure to take your valued insight with us as we submit our final papers for this class and go forth into the world as advocates of human rights in intellectual property.
Yes, and next up, may we hear from attorney Michael De Castro for his reactions to any of the presentations this afternoon.
All right. Part 2. So, maganda yung narinig namin sa session na magsasalita ako sa Tagalog. Mas mabilis ako magsalita sa Tagalog. Marami akong masasabi. Thank you first and foremost kay Professor Santiago for inviting me. I will be wearing several hats while I provide my comments. When I provide my comments, the first and most important hat is, like all of you, I'm still a student. Kasi lahat ng mga abogado dapat forever tayo natututo eh. And so hindi porket ginagawa nyo to at natututunan nyo to ngayon sa law school, hanggang dito lang. No, kasi even after law school, you should be exploring, you should be asking the hard questions. Ako, konting background lang sa akin. I love hard questions. And in fact, litigation is just asking and sticking to uh, asking those hard questions, no matter how far you go. Okay, so yun yung first hat ko as a fellow student. But as a professor of constitutional law, I have to wear that hat and ask all of you, everyone in attendance, number one, what exactly do you mean by human rights? No, because I haven't really heard a definition we can work with. Pansinin niyo, when we deploy the term human rights, it's always para siyang fluffy, no? Parang we don't really know what we're talking about exactly, but there's this semblance here na parang if it's human rights, we that's not subject to debate, no? From the point of view of constitutional law, are we talking about human rights as constitutional law, or are we talking about human rights as international humanitarian law? So iba-iba yan, ano? For this purpose, allow me to just specify constitutional law, which is essentially those principles we have found over the centuries, and we have distilled to take away certain subjects, certain topics away from the subject of debate. No? So it's no longer debatable, for example, na pasukin ng pulis ang bahay ko without a search warrant, without a judge telling us okay lang yan. Or it's no longer acceptable for the state to police what we think, what we speak, subject to certain exceptions, for example. And when we're talking about property and about intellectual property, we're talking about a particular provision in the Bill of Rights we call due process clause, which we can divide into two. Yung no person shall be deprived. Kumbaga, wag mo pabuyan sa akin, pero may clause doon sa dulo na unless may due process of law. So if we look at the first half of that, doon mo mararamdaman yung weight ng substantive due process. Hindi pwede pumasok ang government sa decision making ko, sa bodily autonomy ko, sino pipiliin kong papakasalan, so on and so forth. Pero pagdating na doon sa second half, which is without due process of law, there are certain topics na pwede pa, no? Like for example, expropriation. We can't tell the government, no, you can't take that, because there are certain public interests na accepted, allowed. No, even in intellectual property, as I understand it, and just last month, I think we were able to deploy this argument. Even in intellectual property, there's this public interest exception to patent, to copyright, to trademark. There's always that. In other words, there's a weighing there when property is involved. Okay? When other rights, when other topics are involved, like for example, our mind, the freedom of the mind, nagiging mas mataas, nagiging fundamental siya. So yung fundamental, so sa constitutional law, that particular topic, we divide the protection as rational basis and strict scrutiny. You know, all of you, malapit na kayong mag-bar, I'm sure, inaaral yun na yan. Okay. So, yun yung gusto kong i-clarify muna. Let's be specific. Let's not just call it human rights. Let's call it by its name, by the principle we have distilled. Okay? And so, one by one, isa-isa natin i-discuss. Super bilis lang yung comments. Yung first topic about genetic modification, let me point out, number one, that we have been modifying genes for millions of years. It's just that for those millions of years, hindi natin alam na nagmo-modify tayo. It's a random, semi-random process we call evolution through natural selection. By the way, I'm a scientist. In another lifetime, I was a chemist. So this is I love this topic. No, this is not just human rights to me. This is also creation. So for millions of years, we have been modifying genes. Hindi lang natin alam. But for thousands of years, alam natin, and we have done it through agriculture, yung selective breeding natin, right? Dogs, for example, wouldn't have dogs if we hadn't selectively bred them. Or corn, or every single thing you are eating today, we selectively bred them. It's just that for the last several decades, and super bilis dahil sa CRISPR, nagiging surgical na yung precision natin. And so we have to ask, dito sa topic na to, ano yung kinakabahan tayo exactly? Yung speed, yung precision, yung capacity natin to change ourselves, but haven't we been changing our biology for the last decades through medicine? For example, if, for example, the natural state of things were allowed to go their natural way, wouldn't many people succumb to sickness, to illness? No? And so there's that unwitting genetic modification that's already happening. And if the group here who discussed this wants to move that needle towards a certain direction, you must be conscious of two things. If we're talking about this genetic modification as expression, because certainly for the scientists who are deep into this is an expression of themselves, of their life's work. No? Baka pwede natin protektahan yon under a strict scrutiny standard. Baka. But if we're talking about it as property, like for example, ginawa kita, minodify ko yung genes mo, dinesign ko yung genes mo, akin ka, hanggang saan yon? If for example, I can create a human being from scratch, akin ba yung tao na yon? Diba? We have to start asking those questions. Instinctively, we want to answer that, no, of course not, right? But notice that we have to ask further, bakit? Is there something special about being a human being even if that human being was completely created? So we have to start asking those questions now, because certainly we are needing, and sa topic ng AI, we are needing that point kung saan hindi na human pero tapat na or lagpas pa sa capacity ng human. So we have to ask, part of the deeper question there is, what makes us human and what do we want to protect exactly? No? Sa susunod na topic doon sa IP rights of indigenous people, I have to go doon sa assumptions ng nag-discuss dito. Because as I understand it, nanggagaling yung sino yung nag-present dito? Sino ulit? Ayan, si Gaia. How very apt. No? Parang nanggagaling ka doon sa concept of ownership ng parang civil law and intellectual property, yes? But are you aware, for example, that certain indigenous peoples do not share the same concept as you? Are you aware of that? Like for example, the most beautiful representation of their concept na narinig ko, ganito siya eh. Imaginein mo, langgam ka, and then sasabihin mo, yung bundok na yun sa'yo. Right? How can an ant say that? Sandali lang mabubuhay yung ant na yun, sandali napakaliit niya, sino siya? And yet tayong mga langgam, we are so full of ourselves. Kaya natin sabihin, atin yan. Fundamentally, pag tinignan niyo, for example, yung Carino versus Insular Government at yung Carino line of cases kung saan IP din sila and property rin, fundamentally, pagtatalo siya nung dalawang concepts na yun eh. Akin yan, private property ko yan, sino ka? Right? And so, is there a way, and this is the question here, is there a way for us to make room within intellectual property law for that concept of ownership? No? It's not just akin yan, o protektahan ko yan for my benefit or for the benefit of my community, to something else entirely. I do wonder, baka pwede ang Creative Commons dyan. I'm not sure. I'm not an intellectual property practitioner. Maybe si Dr. Romero or si Professor Santiago makakatulong siya. Sa next topic, sa pharmaceutical patents, napaka-importante nga nito, no? And yet, I believe, I have this instinctive feeling na marami sa mga issues dito settled na dahil nga sa public interest standard pagdating sa property. If it's property, it should be within that realm na pwede siyang pagdebatihan. No? Kasi ultimately, yung tanong na yon ay may weighing. Kung walang weighing, then it's squarely within the constitutional fundamental rights. No? Let me identify rin, let me emphasize yung sinabi ni Dr. Romero dito na kailangan nga maging conscious dito yung team doon sa balancing ng incentives versus yung greater good. No? I recently saw this bill um, created or proposed by Representative Arjo Atayde na pinoprohibit niya ang ang automation and AI. And ang ano niya dito, ang argument niya dito, labor number one, and then maraming down dangers. And I was thinking doon, yung knee-jerk reaction na gano'n na, oh no, what if? Pagbawal. That's such a 20th century thing to do pagdating sa sa legislation. Pag di mo naintindihan, pagbawal mo. There's so much space to create here, and my point is when we're dealing with stuff we don't yet understand, we have to have some deep sense of humility. Okay? Like for example, and I'm going now dito sa AI, I get the sense from the presenters na, oh no, no? Oh no, AI, police, ano pa ba? Labor, paano yung mga trabahador, etc. etc. Paano tayo? But you stop short of suggestions, no? I was on the edge. I was waiting, ano kaya isa-suggest ito mga to? I didn't get it, but that's fine. I suppose sadya yun on your part, no? It was an exploration. But the part here that I invite all of us to be humble about is that for the first time in our history, we have extrapolated, we have created something that can create besides us. In other words, we have automated creation. And so, ang nakaka-humble dito, hindi pala kailangan ng tao sa creation. In other words, hindi siya uniquely human endeavor. I mean, ang mga nag-aaral ng mga primates, matagal na nilang alam yon na mga primates, mga chimpanzees, etc., kaya nila gumamit ng tools. Kaya nila mag-fashion ng tools. But it's just that because of generative adversarial networks like ChatGPT, DALL-E, nakikita natin na, oh no, astig to, nakakatakot to. But let me invite you towards this particular thinking na hindi naman siya kaagad-agad nakakatakot. Kasi, for example, alam niyo ba kung saan nanggaling no word na computer? Anyone here know? Once upon a time, a computer was a human whose sole task was to compute. So pag tinignan niya for example sa sa NASA, yung Apollo missions nila, there was a woman there who was doing all the math. So may photos to, right? And so from a computer, from a human being, naging computer to a thing, but there's still some human intervention there. It's just that this time, hindi na yung tao yung nagko-compute, yung tao na yung nagde-design paano i-compute. No? And so, ang suggestion ko dito, huwag tayo matakot sa bago. Kasi, laging may bago eh. And laging tayo yung nagkikreate ng bago. No? Last, dito sa ano pa masasabi ko dyan? Yeah. Dito naman sa TM protection, sa trademark protection of domain names, let me just pose this question. It's interesting kasi purely ang argument dito is tama ba dun sa nag-present? Nasaan yung nag-present? Ayan. Tama ba gusto mo protektahan from an intellectual property perspective yung hindi registered na domains? Tama?
Likely more of limiting the application of trademarks to uh, registered domains that are not trademark. Sorry.
Not right. So parang hindi siya registered as trademark pero may protection pa rin. Tama yung intindi ko?
Somewhat, yes, sir.
Okay, okay. Um, no, alam mo yung term na nominative determinism. Have you ever heard of that term?
Heard of it, I just can't recall the meaning of it right now.
Yung pangalan mo yung nagde-determine ng ano mo, ng buhay mo at ng destiny mo. In other words, dahil doon sa trademark, dahil sa intellectual property, nag-argue ka ng intellectual property. I have to reverse the question here, the perspective, and I do wonder, may protection kaya from a human rights perspective, from a free speech perspective, ang registration ng domain names as protest, as speech some people would not like. Like for example, let me give you an example. facebooksucks.com. No? I do wonder kung may protection yon. So, yun yung question ko kasi dito. Parang iniikot ko, baka pwede tingnan na rin yung same question from a different perspective. Right? So, all in all, sorry medyo napahaba. Gusto ko maging comprehensive kasi isang beses ko lang kayo malamang makikita sa buong buhay ko. Na gusto ko lang ibalik yung sinasabi ni Dr. Romero kanina na napaka-importante itong discussion na to. We hope all of us, lahat kaming nandito na nauna sa inyo, na hindi dito matatapos yung pagtatanong at paghahanap. No? Kasi certainly nandun tayo sa point ngayon na may mga tanong na hindi pa natin talaga alam kung ano yung sagot. Okay? Yun lang for me. Thank you.
Yeah, Attorney De Castro, thank you so much for imparting your very specialized knowledge in science as well as in human rights. Your passion for these fields is infectious. I'm sure I speak for everyone here when I say the insight you shared with us tonight is truly inspiring, and the questions you posed, especially what are human rights? How do we develop a just and inclusive concept of ownership? These have given us so much to think about. So thank you for that, Attorney De Castro. We hope to we get to see more of you and learn more from you in the future.
Yes, and we really thought we had an idea of how deep this entire thing goes when we started, but I think our little pond, this intersection between IP and human rights, had just turned into an ocean. And again, our biggest thanks to our expert panelists for sharing with us their insight on the presentations we've seen today. Attorney De Castro, Dr. Romero, it is an honor to have you here with us, and we're grateful to have had the opportunity to learn from you today. Now, everyone sit tight because we are moving into our Q&A portion. Throughout the entire presentations, we have had some burning questions, and we might have limited time, but we'll see where it takes us. We will be asking our presenters some of these questions regarding what has been presented.
Yes, so thank you to everyone who have been so active in sending their thoughts and questions and who really contributed to the discourse tonight. We appreciate your sharing your knowledge and perspectives on all these topics that we've covered. Unfortunately, we are, as Charlie said, a bit short in time, but we'll try to cover as many questions as we can. We do apologize for the extension or for extending our time tonight, but hopefully you can stick with us throughout the remainder of the program. All right. So I'm sure my dear classmates are all excited to receive the questions you have for them. Our first questions, our first question is on GMOs. I think this is for Roelf and Uriel. Yes. Anong mas matimbang, farmers' rights o intellectual property rights? Sino ang dapat kampihan ng Estado? Interesting question. Uriel or Ruelf?
Well, as we've seen from Sir De Castro's spiel, that we have to embrace also change. But embracing change must not also come at the cost of actually lessening the rights of, well, though vaguely, what human rights are. So that's why, as we've discussed in our research, in the initial research, that we need to have a balance, at least strive for that, stringent ethical guidelines and robust legal frameworks that should align for these advancements. So, in answering that question, the state should not choose one side. because choosing one side would make you lose the other then. And losing that other can mean potential or or destructible consequences for the benefit of the state in the future. So in my understanding, that should be it. And that's why the title of what we're pushing for is balancing that innovation and ethical stewardship. And I do think and I hope that in the future there is actually that meeting in between.
All right, Uriel, do you have anything to add to that answer by Roelf?
Um, uh, well, I wouldn't say I'm adding, but I just want to emphasize what Barry has already said, that um as we talked about earlier, our research was more on the balancing part. So um as Barry said, the answer isn't actually cut and dry as to who the state should align with. It really depends on the situation, but since these are two human rights that uh may sometimes compete, uh so we really should strive for a balance, because these two rights are um well, they're protected and they're both essential. So
All right.
Okay,
Thank you
thank you
very
so
much.
much, Roelf and Uriel.
Mhm. All right. So let us have another question. This one is regarding our GRATK segment. Um, an arising question on indigenous peoples. Do indigenous peoples' rights establish monopoly? Why does the state assume that indigenous cultural communities or ICCs have inherent ownership to land and traditional knowledge? Why do the few seem to have veto power over the economic activities of those people considered to be part of the dominant or majority population? And as an addition, are we not indigenous peoples as we are all considered as well, considering that the Philippines was not a white settler colony like the United States. So let us have, I believe this is for Gaia, Miss Benjamin.
Thank you. Thank you very much for the question. Can I also answer the other question, which is,
Mm,
I believe he asked, do indigenous cultural communities hold eternal intellectual property rights unlike individuals with expiration that would later become public domain? I think these questions are very related to each other.
mhm,
And they kind of stem from a confusion on the word ownership. So our common conception on the word is based on the Western capitalistic definition of ownership, which is very individualistic. It's important to understand that in the perspective of ICCs, IPs, is that we as human beings do not own the land. We are merely its custodians, its stewards, like what Attorney De Castro said. The reason why states seem to be acknowledging this ownership and seemingly giving them veto power over economic activities is because it's to rectify the historical injustices done against them. So states are not only trying to acknowledge the rights of indigenous peoples, but there's also a an effort to r- to give back what was unjustly taken from them by colonialists and uh, others, and they they continue to struggle with this. I think the comparison between Filipinos, uh, this part of the question here that says, are we not indigenous peoples as well, considering that the Philippines was not a white settler colony? In a way, that is true. We are not. We were never the colonizers. We were the colonized in history. However, um, historically, um, especially after the colonial powers of Spain and the US left, um, the majority the Filipino majority started, or rather continued, to infringe upon the territories of indigenous peoples. So it's not just the white settler colonies that committed atrocities, but we, as the majority, have also committed similar atrocities. For example, in Mindanao, there was this whole um, policy of intentionally moving Christian Tagalogs from the north into, uh, well, not necessarily Tagalogs, but Christians in general, into the lands that were historically held by Moros. And that's just part of this entire discussion. Also, the thing with monopolies is that it requires a definitive person to own, that exclusively owns the thing. That's not the case with indigenous people. There is no single person or even a specific group of people that owns a thing. It's just them as a community. It's also important to understand that traditional knowledge is inseparable to their traditional knowledge is part of in their intangible cultural rights, their very identity. Their traditional knowledge is part of what makes indigenous people who they are. These efforts to protect them is also not just an acknowledgement of uh, the rights of indigenous people. It's also to prevent the tragedy of the commons, to prevent other people from exploiting genetic resources to the point of destruction. I hope that answered your question. Thank you.
Thank you so much, Gaia. And if anyone from the class or from our panel would like to weigh in on this, do feel free to share your thoughts and contribute to the discourse. So, if no one else wants to add, let's move on to our next question. We'll have to bring Uriel and Roel back for this. This is about genome editing. So the question is, human genome research presents one of the most or some of the most controversial ethical issues in genetic research. How would you justify balancing innovation and ethical stewardship to those who are totally against any research tampering with human genes for religious reasons?
I'll go first. So, this is also similar to the previous question asked on whether to choose farmers or choose, innovation. And as we've said before, we will try to justify this research within an ethical framework. And we've provided earlier from our research that genome editing or most modifications in biology in general would be primarily aimed at therapeutic purposes. For example, like treating otherwise incurable genetic conditions, or actually, providing food that can sustain and provide nutrition for a village's worth, for example. And this actually aligns with the broader goal of alleviating that human suffering, which is a principle that it would be resonant with religions and other religious and moral values. So, providing this stringent ethical guidelines and providing an actually robust legal framework is what we should propose and is what should be done to ensure that genome editing is used responsibly, that it should be used within respect for human rights and environmental sustainability. So the emphasis there is that we should not take one side or the other, and we should actually try to reconcile both, because when we try to reconcile both, we try to look at the two perspectives. And having two perspectives would make you see that we cover each other's bases. So, for example, we also emphasize that in genome editing, we can prevent unethical applications by using those moral values, those religious values, because we can prevent eugenics or unnecessary enhancements which would be concerns shared by both the scientific community and actual religious groups. Thank you.
All right, Uriel, do you have anything to add?
Actually, no. Barry already said everything I wanted to say.
That's perfectly fine. Let's move on to our next question.
Yep.
Charlie?
Yes, for our next question, this one is for Jen. For the protection of both our entrepreneurs and the marketplace, should the government require business owners to trademark their domain name in order to run their online business?
See, that's a rather difficult question actually, because uh, trademarks per se are not necessary for running a business. You could run your own business using a mark. What you're affording yourself when you register it as a trademark is the protection from other people using your mark. If that's something you're fine with, you're not really required to register your mark as a trademark. Though with regards to that question, with regards specifically if it should be required, I'd say probably not. However, there are some benefits definitely from one registering a trademark by itself to registering a domain name as a trademark. As we've said, it's the exclusionary right to ensure your consumers that they're getting quality goods because they can identify the goods where the goods are coming from you, the owner of the mark. The thing here about having a national registration is that it's simply not enough because of the point made earlier, I think, that domain names is an international matter. It's not just .com belongs to one place or .ph belongs to people in the Philippines. That's not it. You can be outside the country and register register a domain name using the country code top level domain of that country. Popular examples of that are for corporations using Colombia's country code because it's .co, which is why we used that as an example earlier. So to sum it all up, no, I don't think it's absolutely necessary to to create a registry of domain names registered at trademarks, nor is it necessary for the government to require a registered domain name before engaging in online businesses. But there are certainly benefits from it. So as with a lot of things with regards to intellectual property and human rights, there's a balancing of interests between the person and the protection for intellectual property.
Right. Thank you very much, Jen. These are things to look out for whenever we visit our favorite websites. I'd like to just also mention for some of those who had typed in their chats under the Q&A section and the chat box. Our lovely Professor Santiago is also typing responses, so you could also check if yours received one. Meanwhile, we also have a few questions. This was directed to my co-host Therese. Do you see AI attaining sentience in the future such that it would be more acceptable to recognize AI as authors of their own creation? Now, that's very Black Mirror. Therese, what do you
Yeah,
think?
sorry, Black Mirror. Well,
Mhm.
I wouldn't call it sentience in the way that humans and animals are imbued with sentience, but it is becoming more and more feasible that the way technology simulates this sentience will be willing to recognize rights traditionally attributed to humans to be attributed to these machines who are starting to talk like us, to think like us, and even to look like us. So, having researched AI just this semester alone, there is already an abundance of proof of the exponential rate at which AI is really set to advance in the next few years. So that reality is becoming more and more apparent. That's why I'd like to emphasize in my study that as we grapple with these new innovations, with these new technologies, it's really important to delineate which rights are we willing to reserve only for humans so that we preserve the dignity of the fruits of human authorship, and that we protect these rights accorded to rights possibly being accorded to machines in their own way that is appropriate to the technology without trampling on the rights that we already have now, especially for human authors. So thank you for that.
Right. Thank you very much, Therese. Do we have any further questions here? I think
Ako, I have a quick
Uh,
question
I yes, go ahead,
for
attorney.
the AI team. Kayo yun, ano? Charlie and Therese.
yes, sir.
Ayan. Ang tanong ko, assume that we will reach that point where AI is capable, or automation, any type of whatever we call it, non-human intelligence is capable of what a human is capable of. No, assume lang. Once we reach that point, my question to you is, should that thing, I call that thing, have your rights? If not, why not? Hindi ba nakakaisip siya like you can? If so, then hindi talaga siya human rights. No? Ano sa palagay niyo?
Uh, so I'll go first. Thank you so much for that question, attorney. We in the course of studying our topic, this has come up a lot when we ponder on all the possibilities that technology will take us in the next few years, next few decades, and right now, as it is, um, because it's difficult, as was mentioned as well by Dr. Romero, or by as well by our participants. I think Mr. Santiago also pointed it out. Right now we really don't know where it will take us. We can only imagine. So I can only speak from how it is right now. Um, it's very difficult to attribute still human rights to these machines, although it does sound very discriminatory. There might come a time where the it will open a whole can of worms. These AI humanoids will rise up against us and fight for their rights. But as it stands, AI is very much a tool for humans to advance our society, and it's a means for preserving human dignity. And as you said, we enjoy what we are enjoying now because of this technology, and I don't think that concept has changed. So, given the role um, of the machine, the role of that the machine plays in helping advance or further human dignity and human society, I think these rights should still be reserved to humans because that is the ultimate the ultimate goal, um, to promote these rights. So I think innovation should always look to that end, and if there's any a possibility of taking away from that, I think we should just be very cautious of entertaining that avenue.
I'd
Charlie?
like to take off. Yeah, I'd like to take off on a different tangent there. In the interest of discourse, the possibility of humans attaining sentience has been very. Speculative fiction is very rife with it. We can name a few from the comics. We have Doctor Magnus. We have movies like I, Robot. Of course, the Terminator series. All of these concerning the concept of AIs attaining sentience. But there are some discussions in the field of philosophy that it's not really just the concept of attaining intelligence in the level of humanity. These neural networks are very different, inherently different from human brains. The way that they are programmed, they may achieve the same results as we do. Like, for example, in our discussion on labor, they may achieve the same decision-making capabilities as we do. But the way that they achieve it is fundamentally different, or can be fundamentally different, depending on the progress of this budding technology of general intelligence. There are some commentators who think that the defining point in really granting robots or AI or however we may call them in the future, the idea that they are already sentient is not just their intelligence, but whether they have achieved the concept of the I, the concept of the self, which there are those whom intersect it with the concept of human rights and copyright as well, is that this concept of I is what makes us human, is what gives us right. The moment that we are aware of what we are, the moment that we are aware not just of the processes, but of the way that we process those processes, a very meta thing. But the moment that we have this in our minds, then we have achieved a level of intelligence that is so far reserved to humans and some primates, and the crow and a few birds.
And the question
Yes, sir.
assumes that.
Mm.
I mean, the question is of parity, no?
Mhm,
In terms of capacity and in terms of ability, it's the same. That's the question.
mhm. Yes, sir.
You
If
didn't
that is
really
the
answer it,
case,
Charlie. Yeah.
sorry, sir. But if that was the case, I would assume that yes, we should grant them similar rights. Maybe not calling it human rights in this case, in the same way that in the past, the same human rights were not granted upon all humans. Maybe in the future, this concept of AI will rise as a different race and merit their own rights because of such sentience or because of such self-awareness. But
Okay.
intensely speculative.
Um, Let me contextualize lang ng sandali. Once upon a time, there was this argument that there were a lot of things that are only things because they're different. Okay? So if you've ever read Dred Scott, for example, are you aware of that case? Kung saan question ng isang African American ang kanyang sariling pagiging slave pero hindi siya binigyan ng standing dahil property lang daw siya. So it justifies slavery, no? That argument, you're a thing, slavery. So parang siyang may parallelism dito eh. Gusto ko lang parang ano yun, tingnan natin. Eventually baka maging question rin yun. Yun lang. Thank you.
Yes, thank you so much,
Thank you,
Attorney
sir.
Taff. And in response to that, yeah, we definitely have to be careful of because the line between these arguments can be so thin. So we'll definitely that's a lot to consider. And to add to the discourse, we have a comment from one of our participants, Mr. Adrian Manalaysay. So thank you, Mr. Adrian, for sending this in. He says, maybe AI rights would be similar to juridical or corporate personality. I think it is too early given that it is only beginning and we do not have much experience to rely or base on. The arising questions would be, should we really formulate guidelines, laws, policies about AI now, or should we wait and see? Or should we just simply promote social responsibility? So that's something for us to chew on as we move to our next part of the program. Unfortunately, we don't have too much time now. So, thank you so much for your questions, and hopefully, we were able to address everyone's concern. All right. So, um, yes, I think we're on to our last part of the program. Just to wrap things up, let's hear from our beloved project head, without whom none of this would have ever been possible. Ladies and gentlemen, please welcome the lovely Miss Gaia Benjamin for her closing remarks.
Thank you for that introduction. Good evening, everyone. On behalf of Law 194A, we would like to give our sincere thanks to everyone who attended and showed interest in our class project, especially all of you who stayed all the way until the end. Please give yourselves a round of applause. A broad variety of topics were discussed tonight, and we hope that these presentations not only contributed to your understanding of whatever we talked about, but also sparked your interest and encouraged more discussions and questions and how even something as technical as intellectual property can intersect with our fundamental human rights. We would like to thank our reactors who took the time out of their busy schedules to attend and share their deep knowledge and insights on our topics. Finally, we would like to thank our professor, Attorney Josephine Santiago, for not only instilling in us knowledge on intellectual property, but also a sense of justice and ethics. Thank you for being a wonderful mentor for all of us. Thank you once again for attending, and we wish you all a very, very good night.
Thank you very much, Gaia, for all the blood. Yes, I think we have someone. Oh, sorry. Yes, thank you very much, Gaia, for all the blood, sweat, and tears you've shed for this project. And thank you to our dear audience members for joining us today. Personally, we have learned so much from our classmates and from you as well. And I truly hope that you guys can say the same for us. We hope that just a little bit we have opened some doors and some avenues of future discourse here.
All right, I know everyone must be hungry now. It's dinner time. But before we go, may we ask everyone to turn on their cameras for a quick picture taking so we have a little memento to take with us and cherish as we officially end this semester. So if you'd like to join us in our picture taking, please turn on your cameras. We'd love something to remember this event by. All right, Gaia, are you going to be the one to take the picture?
Yes, everyone who has a camera, please turn it on.
Okay, ready?
Ready? And say IP.
IP.
Okay. Next page.
There's several pages. All right.
Yep.
Oh, wait lang. Sorry for the delay. All right. Thank you very much,
Smiling.
everyone.
Thank you so
Yes.
much, Karen. Thank you, everyone. Again, on behalf of our class, we hope that our simple event inspires you to explore intellectual property through a human rights perspective. I am Therese.
And I'm Charlie.
And we are
And
I am so sorry, but
oh,
I would also like to give thanks to our UP comms. Thank you so much, and apologies for skipping
UP
you
comms.
in our
thank you,
closing
comms.
remarks. They were the
And we
ones who handled the live streaming and this webinar style. Thank you so much, UP.
so much,
Thanks,
UP comms.
guys.
Congratulations on the successful webinar. Yeah, so that's it, I think, for tonight. We're signing off. Thank you, everyone, and good night.
Thank
Bye.
you.
Thank
Thanks,
you.
guys.